आज the last date that advertising the result as election is
There will be no court, sir. So,
Monday.
Monday.
RSA matter case admission milord. This annual court order data 16/7/2024 direct to file certified copy. I have already filed the certified copy. The execution case ta 5
Beg your pardon, my lord.
Oblige.
Beg your pardon, my lord. Mention, my lord. This is the second appeal of 126 of 2019. My lord, it is a declaration for right title, interest, and confirmation.
What is the urgency?
Urgency, the appellant is trying to alienate the property, my lord.
My lord, this is a second appeal of year 2010. The urgency is the petitioner is trying to change the nature and characteristics of the suit land. So,
What is the meaning of changing the nature and characters? What is he doing? What is he attempting to do? Yes, you said he's trying to change the nature and character of the suit land.
yes,
How? By what means? What is he doing there? Not prepared.
no, I was instructed that
No, you are not prepared. Not prepared means the court will not accept. Anyway, look, item 1. Supplementary list item number 1 to be mentioned. No, this, I was preparing for judgment. I was, he had told that all these petitioners were petitioners also in the earlier case.
Original writ application, they were there.
No, that I could not find. So you have to give a chart.
Yes. So, just a batch of writ applications were filed on the ground that their applications were rejected on the ground of age.
Sir, can we take? I'll take note. I think if it can be again. See, part
detail
detail se chat kari because I did not find.
Yes, because a judgment or batch of cases have been disposed of by a common judgment.
So first, what happened?
A batch of writ application were filed before this honorable court, single judge, challenging the action of the authority not entertaining the application on the ground that age barred, overage. So this honorable court disposed of all these applications directing the state that one time scheme you prepared, the enhancement of age 42, because last year you had kept it to 42, and this year thereafter they decided and made a scheme 42 years.
Yes.
Then their application filed, they went for consideration of their case. By that time, third preference already over.
Yes.
Two preference already over. Third preference, they could not be able to exercise their exercise of third because the posts were not available according to them.
Yes.
So they approached this honorable court. In some cases, this honorable court directed that consider their case, and that judgment was challenged before a division bench. Petitioner were not before the division bench, but the petitioner were in the original writ applications. Division bench said 7 because state council took the instruction and placed it before the honorable division bench that 7,000 some odds 706 for vacancy are still available. So the division bench said, since these people there, by the time the writ application were disposed of, you have already exhausted those vacancies, that preference could not be exercised by them. So if vacancy are there, let them be accommodated. So for the appellants, they said that appellant should be accommodated. That is what the direction is. They challenged before Supreme Court. Supreme Court upheld that judgment. Now, so for the review has dispute. Now the present petitioner, their entire claim is that they also stand on the similar footing, exactly similar footing, only they have not preferred an appeal. They have not preferred any appeal. But the order that your worship, last time also your worship raised that point, I will also come to page 22 of that appeal, that writ petition.
In which
In WPC first Madan Gopal Nandi 0653 of 2021.
40653, yes.
Yes, sir. Kindly come to page 24. You also have marked it last time also. You also put that question to State Council also. 37, 2015.
Yes.
You also kindly come to last but 6 line.
Yes.
Overage candidate, those who have applied online and obtain the positive direction from the Honorable Court will be given the opportunity to select a district, if not yet engaged in any district, having all other eligibility for the same. By that time, this on 37/2015, two preference already over. So this was the order. And again also on the selecting authority OPEPA, also same thing. You also look to that page 25. OPEPA also directed all district project coordinator, referring to this comment order, that you also look for first paragraph. With reference to the subject cited above, I am directed to intimate you that the engagement of eligible candidate in the post of Shiksha Sahayak during the year 2014-15 in their first and second preference choice district has been completed. Therefore, you are required to prepare merit list of candidate of the third preference choice district for the post of Shiksha Sahayak in your district, including the overage candidate whose list has been submitted to the concerned DPO by SPO, or the candidate have submitted the order of the Honorable High Court directly to the DPC. It will also be looked to the division bench judgment, which that is at page, so state come to page 43, starts page 48. Page 48. Sashikanta?
Yes.
Page 40.
Yes.
The appellant's grievance is only to accommodate them on vacant seat with the enhanced operating limit. SK Samal on counsel for the appellant submit that as per the information sought under RTI, there are about 7,062 number of posts of Shiksha Sahayak which are lying vacant after the select Shiksha Sahayak pursuant to the completion of recruitment process as per the advertisement published in 2014-15. Since sufficient number of posts are lying vacant, the appellant can be easily accommodated without disturbing any selected candidate. The last portion of your lordship order can see the division bench order. At page 49, para 12. On perusal of the record materials available on records and considering the submission of the Land Council for both sides, we set aside the order dated 29/11/2019 passed by Joint Single Judge in WPC number 16711 of 2016 and a batch of cases. In these batch of cases, I am also petitioners. That order is set aside. However, not that set aside confining to those persons who have approached the in division bench appellate. However, it is made clear that since there are unfilled vacancy of post of Shiksha Sahayak available against which the appellant could be accommodated, we therefore direct the respondent to accommodate these appellant against the said vacant post. Now, these petitioners, this was also upheld by the Supreme Court at page 54. That's right. Now, why they have rejected also time to come to page 58. These petitioners, they approach your lordship said directed to consider the representations, keeping in view the judgment, in the light of the judgment.
Yes.
And this is the page 58, the last person order. In view of the reason assigned above, more particularly, on the fact that the Honorable High Court specifically directed to accommodate the appellants of the above writ appeal, the benefit of the same cannot be extended in favor of the present petitioner. But further, the government policy does not permit to engage in ineligible candidate. Ineligible means
I'm actually stuck here because whatever they say with that would the court will have to take a call whether it is a judgment in rem or in judgment in personam. That's a different. But I would on fact also. Mr. Samal repeatedly said that the petitioners were also one of the petitioners in that Babita Satpathi's case.
in the writ petition.
No. Out of 4 writ petition, one that is name is Vidyadhar Naik.
Yes.
Was one of the applicant in Babita Satpathi.
There
were 35 applicants. So
Vidyadhar Naik is
disposed of
already
disposed of.
Vidyadhar Bhul aschi, Vidyadhar Naik has already been disposed of.
No, I would like to know that so you had approached initially the single judge.
Single judge did not entertain that. But some of the candidate they preferred an appeal. Appeal, this was the order.
But admittedly, you did not prefer appeal.
I did not prefer the appeal. But the order of the single judge was set aside by the division bench.
Set aside in relation to those appeals which are
That's a common judgment. Judgment was passed a common judgment, but same judgment. Same judgment. The whole question is still the vacancy are available, and I found, and admittedly they have not exercised the option, third preference option, because by that time already 2 options have already been exercised, already adjusted. your lordship have held in other advertisement of 2016, there are 22 preferences are there.
30 preference.
30. Your lordship said that till the preferences are exhausted, you have to continue.
That is the rule.
That's the rule. Here is five preference. Admittedly, there are 5 preference, but they have not given after second preference.
No, let us say, for example, this first petitioner, Madan Gopal Nandi.
Aye.
What was the writ petition filed by him?
Say number ସେ number ଗୁଡା list କରିଦବ ନା
ଆଜ୍ଞା
ଏବଂ ସେ judgment ଟା ଯୋଉ single judge judgment ର ଦବ ଯୋଉଟା dismiss ହେଇଥିଲା
Madan Gopal Nandi, then Sarath Kumar Ratha.
ଆଜ୍ଞା
he is preparing a list. I also cannot
All right.
consume time. He will prepare a list and give to you.
All right.
Including the judgment which was set aside.
Yes. So these 3 writ petitions, they were initially dismissed.
Yes,
You did not prefer any appeal.
I didn't.
Some others preferred an
Yes,
appeal.
yes.
So I would like to know whether these judgments, so they remain as it is.
So that is exactly the point. If the judgment has been set aside by the division bench, which was the basis, whether all these petitions were there, in that case, whether that judgment cannot be said to be remain in respect of others persons. That is what I am trying to impress your worship.
No.
Judgment set aside means set aside for all.
Hey, that is true. Even if he has
So now
not.
the only question is,
So this is a very absolutely factual aspect.
yes,
In the sense that
yes,
what was the writ
right.
petition?
Whether they had approached the Honorable Court.
What was the writ petition?
Application, which is number of the writ application, they were disposed of in which date.
Madan Gopal Nandiraj.
कितना drawn? Writ petition number
Application number 21968 of 2014.
21968 of 2014.
এই judgment টা
2014.
challenge হয়েছিল।
Now this was never challenged. Yes, was it challenged? It was never challenged.
এই judgment টা जो
Some others had challenged it.
some others
And rightly or wrongly, whatever, the court in the division bench, they said that these applicants, that word,
that's it, that is right.
that is causing all difficulty.
That's right. You
Confined.
said that appellants.
No, these appellants will be litigation. Last year.
Appellants lecture. কিন্তু স্যার আপনার আপনার এই কথা বি উঠিଥିଲା but your lordship referred to these two annexure 3 and 4 जो sorry annexure 4 and 5 जोटा के 37 2015 और 31 7 2015 जो कहले those who have obtained the positive order from the court, they have obtained the positive order from the court as a overaged candidate to be considered. Your lordship, for the timing, let us forget that division bench judgment. My submission with your lordship would be that if they themselves have judgment was passed, so far the overage is concerned, that that has been now accepted, we have decided. By the time the judgment was passed, while they approached the authority, they said that because the second preference is over, they should have allowed to exercise their option for the third preference. Different district, because what the vacancies are available, but they have not done it, and they themselves government issued a circular which was also implemented by the OPEPA that the again look to that those overage candidates, those who have obtained positive order, they should be so bereft of the judgment of the division bench. If this will be accepted, then certainly also they are entitled to get against the vacancies available. My right goes from two. Also, for the time being, because of the division bench, because that may be confined to that appellant.
Yes.
So let us now see that so far as my judgment, so far as the condonation of age is concerned, relaxation of age is concerned, I have got the judgment. And that judgment you yourself have accepted, but admittedly you have not accepted his option in third option. Even if two already done, 2 already completed.
Yes.
But they have right also even 1 or 2 because they are in the merit list, they have position is much higher. Only because of the age they are disqualified. So therefore you yourself have accepted those who have obtained the court orders, court cases, then you will do it, and you have not done.
All right. You give a chart.
My lord.
No, there are initially you had also approached this court where that overage thing was,
My lord.
overage order was passed. So that you have to give first.
My
First return. Then the subsequent writ petition when they did not comply with that order. I mean, they did not go for the third preference.
My lord.
Thereafter, you stayed quiet, you did not file any.
Right.
Yes, Mr. Das, you would like to say anything?
There is nothing except saying that if your lordship considers this division bench judgment as in rem, then it would be applicable to all.
Because why you see, one may also think of it in another manner. This whole business of including overage candidates
Yes.
was earlier considered by a single judge, probably. and the direction was issued, whereupon all these things have
Yes,
started.
yes, yes.
Otherwise, they did not have any,
There are-
they were all over it.
Yes, sir.
Yes.
So what happened is you stopped at the second round saying that it's no longer possible to accommodate them. Subsequently, again, you went for the third round. And when the matter went to the division bench for some reason said that it is applicable to these applicants.
Yes.
That is why they have not been considered. This is the case. I think it will be a question of principle. Apparently.
As your lordship
I have a
would
point
yes.
to be
Yes.
added to your subject to your is accepted. Suppose my prayer, because they have not accepted third preference, was rejected by the single judge. And so I have not prepared an appeal. But the moment you decided pursuant to that judgment to open that third preference, have I not that right to at least to say that on principle that I should give me also third preference, I have got the merit. And my case is that these persons are more meritorious than those candidates.
So what happened? Why was the second writ application dismissed? Order କଣ ହେଇଛି?
Justice is simple. That's the case.
ସେମାନେ ବସିଲେ ଏମାନେ ତାଙ୍କ ଭିତରୁ ଏମାନେ କିଛି ଆସିଥିଲା
No, yes, in the present petitioner appellants, they are not approached second time.
No, they have WPC ଆପଣ number ଟା କହିଲେ?
ସେଟା ହଉଛି ସେ ଯୋଉ case
21968 of 2014. ସେମାନେ କରିନାହାନ୍ତି।
those who have obtained positive
ଏଇଟା ଦେଖି
ଆଚ୍ଛା ସେକେଣ୍ଡ ଟା ସେମାନେ କରିନାହାନ୍ତି।
ନା
second ଟା ଯେ ଦେଖ your lordship is second ଟା reject ହେଇଥାନ୍ତା that is another
That is what I'm saying.
another hurdles.
This is all it. ଏଇଟା ଆମର ତ ଆମେ call for କରିଦବା।
ଫାଇଲ ଟା ବି call for କରିଦେବା।
I direct that the upper age limit shall be fixed to 42 years for the consideration of engagement. You give the number so that you can confirm. ହେଲା ତାପରେ order ଟା କରିବ order ଟା ମୋଠୁ କରିଦେବ ସେ number ଗୁଡା ଦେଲା ପରେ number ଅନୁସାରେ order ଟା call for these files concluded
one matter was already in the lordship's board but somehow this has not been listed
today.
on my that is WPC number 40661
It was heard on that day.
my lord
ତାହେଲେ ସେ ଥିବ ସେ ଅଛି ଅଛି।
ହଁ
last item ଟା ଭୁଲ ଆସିଯାଇଛି
ସେ ବିଦ୍ୟାଧର ନାୟକ ଟା କଟିଯିବ already
dispose of already ସେ ଆଳୁଟା case
list
Item number 2, press admission.
may I lord sir
Yes.
Last occasion,
The consolidated writ petition was filed, I was directed to take the instruction in this case, madam, because the first round litigation, his representation has been rejected. And impugning that rejection in the consolidated writ petition, my lord,
Yes.
yes, fine, yes, ma'am. My lord, I have to get instruction, but till that, my lord, I have not received any instruction, but after going through the impugned order, what we have rejected, and after going through the pleading of the petitioner, my lord, what I found, that our rejection, his grievance in the previous round litigation is is making with a comparison with that Bobita Satpathy case, madam. That 2014 selected Bobita Satpathy over his candidate. But in fact, his case has been considered as per the impugned order, my lord, in terms of that judgment, while rejecting his case. But fact remains, my lord, the petitioner, according to his own submission, he is not an overage candidate.
Okay.
He is a SCBC candidate, and he was by that time, my lord, he was only 35. So he was very much.
So what is his prayer? What is his prayer? Let us see. Let us complete it today. We'll close it today.
I have one doubt, my lord, only in my mind, my lord, that he has enclosed the previous writ petition, where after discussing with him, my lord, actually I got that information that he had exercised the first preference against Kolahandi in the district of Kolahandi as a SCBC candidate. And he is relying upon a document wherein it is indicated that the left out vacancies includes total number of 7 number of posts under the SCBC category in Kolahandi district. I have I have to take the instruction only to that effect, that if the person is otherwise eligible and had exercised his option as the first preference for Kolahandi district as SCBC category candidate, and admittedly there are 7 number vacancies, what is the reason for not?
No, let us see the rejection, recent rejection which you have incorporated, which has challenged.
My lord, what I found, my lord, that it is completely basing upon that overage, and I don't think that, my lord, that is properly appreciated. If
Where is
it
that
is
case?
correct that the petitioner is belonging to SCBC category, and it is also correct, my lord, that he was also within the age of 35, my lord. Why he relied upon that decision and a direction was there, my lord, to consider his case in that light, my lord.
I'm unable to find. Where is the consolidated application? Where is the
That is at annexure,
annexure?
it is annexure 6, my lord, annexure 5. It is at page number, corrected page number. So, say something. Yes.
1188.
1142, 119, my lord.
It is not there. He has not filed a consolidated application. I'm unable to get it.
Yes, sought a copy upon it.
This 2/2/2024, annexure 5.
Yes, yes, my
Order.
lord. Yes, yes.
By relaxing the age. The relaxation of age because maybe at the time of consideration he was well within the age, but subsequently he may have become overage. That is why probably this court said that if necessary,
He relied upon that decision of the Satvati case.
which is not applicable.
Well, at least what I came to know, because his own pleading says that, my lord, he belongs to SCBC category, having 5 years of 5 years relaxation. And he was, by the time when he applied for the post, my lord, he was only 32.
So he's not.
35. So, my lord, he was very much within that age relaxation, age operation limit, my lord. So, why he relied upon, my lord? But, my lord, I am not in this particular rejection order, my lord. This rejection, irrespective rejection order. Only I want to take the instruction because this, actually, my lord, it was on 10/7/2024. I was directed to take instruction there on 18/7, my lord, on the consolidated. So I had already instructed them. I have to take only one instruction, my lord. What I found from the documents, that he had exercised his preference for the as a first preference in the Kolan district. He has also relied upon a document of the vacancy which had left out, my lord, after the 2016 recruitment process, my lord. There it has been indicated that 7 number of SCBC posts are lying vacant in Kolandi district. If posts were there and he had exercised his first preference, had it been a case of third preference or fourth preference, my lord, Mamta Naik case principle that will have its application and again he will be considered another thing. But while exercising the first preference, if he had not been considered, there must be something, my lord. That is why one such may be given so that I can get that instruction. Why, irrespective of exercising his first preference as Kolan district and vacancies were there under SCBC category, his case was not considered relevant point of time. The lordship may specifically quote this one.
Yes.
ମୋର ଟିକେ ସମିଶନ ଅଛି ଆକ୍ଚୁଆଲି ମାଇଲର ଏ କେସରେ ଆଉ କିଛି ନାହିଁ ମମତା ନାୟକ କେସରେ ଏକ୍ସାଇଟିଂ ଭ୍ୟାକେନ୍ସିରେ ଅଲରେଡି ଅର୍ଡର ଦିଆହେଇଛି ତ ଯେହେତୁ ମୁଁ ଇଲିଜିବୁଲ ଅଛି ଆଟ୍ ଦ୍ୟାଟ୍ ଟାଇମ୍ ତ ମୁଁ ବି ସେ ଗ୍ରାଉଣ୍ଡରେ ପାଇବାକୁ ଇଲିଜିବୁଲ ଯୋଉଟା ମୁଁ ପ୍ରେୟାରରେ ଲେଖିଛି ଆଉ କଣ ପାଇଁ ସେ ଟାଇମ୍ ନେଉଛନ୍ତି ମୁଁ ଜାଣିନି ଆଜି ହିଁ ସାଥ ଦିଅନ୍ତୁ ମାଇଲର ମୁଁ ଟିକେ ଇଏରେ ଯାଉନି ସବୁ ଲେଖିଛି ଓଭର ଏଜରେ ମତେ ତ କାଟିଲେ ଆଉ କନସିଡର କଲେ କେତେବେଳେ ଦେବେ ପୋଷ୍ଟ ତ ବଳକା ଅଛି ତ ଓଭର ଏଜରେ କାଟିଛନ୍ତି ମୁଁ ଇଲିଜିବୁଲ ପିଲା ମତେ ଓଭର ଏଜରେ କାଟିଛନ୍ତି କଣ ଆଉ ହବ
No, you were not overage at that point of time.
ହଁ କିନ୍ତୁ ତାଙ୍କ ରିଜେକ୍ସନ ଅନୁଯାୟୀ ସେ ବନିତା ବିଷୟରେ ଗୋଟେ ଅର୍ଡର ପକେଇଛନ୍ତି ସେଥିରେ ସେ କହିଛନ୍ତି ଯେ ତମେ ଓଭର ଏଜ ଅଛ କଟିଗଲ
So that is
ପ୍ରୋସେସରେ ନେଇନାହାନ୍ତି ଆଉ କଣ ଇନଷ୍ଟ୍ରକ୍ସନ
That is
ଆଣିବେ
wrong.
ସାଥ ଦିଅନ୍ତୁ ମୁଁ ବି ଆଉ ସମୟ ଦେଇପାରୁନି ଆବସେଣ୍ଟ ହେଲାଣି ମୋର ତ ମମତା ନାୟକରେ ଇଲିଜିବୁଲ ପିଲାଙ୍କ ଅର୍ଡର ଅଲରେଡି ପାସ୍ ଅର୍ଡର ଆଉ ସେ ଯୋଉ ଭ୍ୟାକେନ୍ସିରେ ଦେଇଛି ସେ 4000 ସମଥିଙ୍ଗ ଭ୍ୟାକେନ୍ସି ଅଲରେଡି ଅଛି ମୁଁ ସେ ଦେଇଛି ଭ୍ୟାକେନ୍ସି ପୋଜିସନ ଆଉ କାହିଁ ଏ କେସରେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇକି ପୁଣି
No. ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବାକୁ ଚାହୁଁଛନ୍ତି ଯେ ଆପଣଙ୍କର ଯେହେତୁ ଏଜ କମ ଓଭରେଜ ନଥିଲା ଏବଂ SCBC ର ସେତେବେଳେ ଭ୍ୟାକେନ୍ସି ଥିଲା so why were you not considered? That is what
ସେ ଅର୍ଡରରେ ସରି ମୁଁ ମୋ କଥାଟା କହୁଛି ସେଟା ତ ଅର୍ଡର ସେ ମେନସନ କରିଦେଲେ ଯେ ଆମେ ତ ଆଉ ପୁଣି ତାକୁ ସୁଧାରିଲା ବେଳକୁ ମୋର ତ କ୍ୟାରିୟର ଗଲାଣି ନା ତ ଏବେ ତ
ଆପଣ ସେ ଯୋଉଟା ସେ ଅର୍ଡର କଲେ ଯେ ତାଙ୍କର Could say, where is that order? Where is that impute order?
114, my lord. 2/2024.
Yes. What do they say?
My lord, there we have stated, my lord, that the petitioner, because he claims the parity with that Babita Satpathy case, my lord. And Babita Satpathy case was relating to the overage cases of 2014 recruitment. And the petitioner is a 2016 recruitment. And that cannot be cited as a precedent for everybody. And second thing, of 2016 cases, 2016 recruitment, some of the persons they had approached before this honorable court in WPC number 548 of 2017, that is Bonita Biswar and others, and their cases have been rejected.
So
With respect to the overage.
So his case was originally rejected. Why that is the reason why he
No,
came to
madam,
this
that
court?
is not there. This is
No,
the
why did he come to this court?
Madam, this is the repentant.
No, this
Madam,
is subsequent. But why did he come to this court?
He approached before this honorable court in the previous round, saying that in the light of Babita Satpathy case, after a long period, my lord, in the light of Babita Satpathy case, my case may be considered. I have made a repentation. That was directed to be disposed of, my lord. And that has been considered in the light of Babita Satpathy case, and they came to such a conclusion.
No, that was during pendency of this writ application. That is why he was permitted to amend this 2/2024.
No, my lord, this has been filed saying that no decision has been taken, but later on it was brought to his knowledge that this has already been passed in 2024.
So 2/2024 is the impute order.
Presently, my lord, this is the input order.
Here, what has been held that he is a overage candidate.
Overage
So,
candidate.
and Babita Satpathy cannot be applied.
Yes.
You forget about Babita Satpathy. But you yourself are now saying that he was not overaged at the relevant time.
My lord, I am making a submission on the basis of the material what it is available now presently on the record.
Yes.
The petitioner declares his age that he was 35. The petitioner declares that, my lord, he is SCBC. The advertisement stipulates that, my lord, there is a 5 years relaxation for the SCBC candidate. So, my lord, he cannot be discarded on the ground of overage, my lord. But why he relied upon on that particular decision, and it is his case, my lord, that has been considered in that way. But once I am taking
Anybody
going through the
in your
documents,
previous writ application, were you conducting it yourself or ଆଉ କି lawyer ଥିଲେ ଆପଣ?
ଲୟର ଥିଲେ ଆଜ୍ଞା। ମାନେ ମୁଁ ଗୋଟେ ସବମିଶନ ଦେବି, ଏଇ ଯୋଉ ମମତା ନାୟକର ବି ଅର୍ଡରଟା ହେଇଛି ସେଥିରେ ବି ବବିତା ଶତପଥୀର ଆପଣ କୋଟିଂ ଦେଇছে।
ଆପଣ ବୁଝିନାହାନ୍ତି ଗୋଟେ ଜିନିଷଟା ସେଥିପାଇଁ ଆପଣ କହୁଛନ୍ତି he is trying to help you ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି।
ଟାଇମ ଅଲରେଡି ସାର୍ ଇଏ ନାଟକର କ୍ଲାଇମାକ୍ସ ଅଲରେଡି ହେଇଯାଇଛି, ପୁଣି ସେଥିରେ ମଝିରେ ଟିକେ
18/7/26
ଆଜ୍ଞା
ମାନେ ସେଥିରେ ପୁଣି ଇଏ ଇନଷ୍ଟ୍ରକ୍ସନ ନଉଛନ୍ତି ଅଲରେଡି।
medicine knowing patient and law knowing litigant very difficult to handle। ଆପଣଙ୍କୁ ସେ ହେଲ୍ପ କରୁଛନ୍ତି ଡାଇରେକ୍ଟଲି ଆପଣଙ୍କୁ ହେଲ୍ପ କରୁଛନ୍ତି।
ନିଅନ୍ତୁ ଟାଇମ ନାହିଁ
ଆପଣ ବୁଝିପାରୁନ ନାଇଁ ଟାଇମ ଟା ମୁଁ ଦେବି ଆପଣ ଦଉନାହାନ୍ତି।
ଠିକ ଅଛି ଓକେ
ବୁଝିଲେ
ସରି
ଆପଣଙ୍କ କଥା ଅନୁସାରେ ଟାଇମ ଚାଲିବନି।
ପ୍ରଫେସନାଲ ନୁହଁତ ଟିକେ
ନା ବିଲକୁଲ କାହିଁକି ଆପଣ କିଏ କହୁଛି ପ୍ରଫେସନାଲ ଯଦି ନୁହଁ ଏଇଭଳିଆ କଥାବାର୍ତ୍ତା କରିବା ପାଇଁ ଆପଣ ଚୁପଚାପ କହୁନାହାନ୍ତି କୋର୍ଟ ଛାଡି ଦିଅନ୍ତୁ। କୋର୍ଟ will always try to find out the what is good for you। Court will look at the litigant, remember that।
apologize
ଆପଣଙ୍କୁ ସିଏ 3 ଥର 4 ଥର ଷ୍ଟେଟ କାଉନସିଲ କହୁଛନ୍ତି ଯେ why you are not considered even though you are not overage। ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି କଥାଟା। I record it। ମୁଁ ସେଟା ରେକର୍ଡ କରି ତାଙ୍କୁ ଦେବି।
yes, that may be.
In course of hearing, it is brought to the notice of this court that the petitioner was aged about 35 years at the relevant time, and being an SCBC candidate, he was entitled to age relaxation of 5 years. So as such, he cannot be treated as an overage candidate. Furthermore, it is brought to the notice of this court also that there were 7 vacancies। 7 ना कहते हैं?
Yes, there were 7. Sir, it's a ठीक है। ता पूर्व sentence now, he had exercised his first preference in the district of Kalahandi। Yes,
Furthermore, he had exercised his first preference for Kalahandi district।
Kalahandi district, and now he's relying upon a document, my lord, which shows that there are 7 number of SCBC vacancies in Kalahandi
And
district.
that there are 7 vacancies in the SCBC category in the said district। Learned State Council shall obtain specific instructions as to why the case of the petitioner was not considered in such a fact situation। List this matter next week। Next week we will close it। Don't worry। ଯୋଉଟା ଆପଣଙ୍କ ପାଇଁ ଭଲ ହବ ଆଜ୍ଞା। ଏଟା କୋଉ ପର୍ସନାଲ ବ୍ୟାଟଲ ହଉନି। Release this matter next Thursday करो 5th August 5 ଅଗଷ୍ଟ ନା 8 Oh, 8th August, all right.
5 ରେ ଦେଇଦେବେ 5
Yes.
Item number 3.
applies.
Item 3. Yes, this was heard, I think.
May I plead lordships?
It was heard in detail.
So in detail, your lordships wanted my.
Oh, that you were,
Yes,
court would like to know whether the post of PET was advertised in any manner. Mr. B.K. Patel and Council shall take instructions in file an affidavit study. Where is
I
your
have filed the affidavit.
your file?
Filed, yes.
Here about the stand in. Additional affidavit केबे फाइल करछन्ती?
In fact, 22/7/24 रे.
May I just hand over my copy?
Yes, it is there. It is there. It is there. You have styled it as additional affidavit.
Yes.
Additional affidavit on behalf of OP4.
Yes.
In the newspaper, it had been published.
अब पूरा पूरा खबर कास्ट नदल किन जानिबा? पूरा खबर कास्ट नदल किन जानिबा? यार फर्स्ट पेज रो सेकंड पेज से तो कोन लिंक अछि?
राष्ट्रदूत बिली लिखुचंती.
नहीं राष्ट्रदूत है ना किसी माना नहीं. It shows that they have, but the first page and the second page, how are they related? How do we know that? ये पूरा दो ना थी पूरा खबर कास्ट फाइल कर दूं तो मैं तो आज ही तो क्लोज कर दो सरला हो पूरा खबर कास्ट दे दी था तो आखिर पूरा मेमो कर फाइल कर दो
मैं मेमो करी फाइल कर.
पूरा अच्छी तो
हाँ पूरा अच्छा. The fact in short and limited is who had been appointed as a PT of Kaptipada College. My prayer before my Lord is that it is OP number 6 who had been appointed as PT of the college. But the appellant says he had been appointed and he continued. From 1992, he was not permitted to put his signature in the teacher's attendance register. Because of this, he approached to DPI. DPI said, yes, he is the PT appellant. Then, being aggrieved by that order, he filed that how that order will be implemented.
all these things have been argued in extensively.
Before
repeat करें कौन कर
no, I am not repeating it. But where something has happened, I am just drawing my Lord's attention. Two things my Lords have directed me to say that he was an examiner as a lecturer from 1989 onwards, but he was not there. He was not examiner, but he had worked for some days, not being appointed by the authority, but for some other reasons, because of the interference of the secretary, previous secretary, and thereafter other secretary. But he has not been given appointment, and the appointment letter which he has annexed, my Lord, does not contain anything except the date. Nothing else, no date of issuing the letter or letter number, anything of sort. This is one thing. So, question of deputing or examining or as an examiner does not arise at all. Number one. Number two, he is a PET. Lecturers are sent for invigilation in board examinations, but he is not a lecturer or he has not been appointed, and he says that he has been appointed. So that is not correct. Secondly, in course of argument, my Lords wanted exactly to know whether the post has been followed by following the procedure of law that is in the publication. So I have attached, which I shall give the full paper. That will be. So the two problems my Lords had put it. But my Lords, only I want to say 76, page 76. They had appellant approached to Hon'Ble Court. Why his order of a DPI is not being carried out? We approached to the Hon'Ble Court that the order passed by the DPI is wrong, defective, and illegal. So 3 writ petitions were heard by this Hon'Ble Court, and my Lords quashed the DPI's order, holding that the appellant is the real PT of the college. That order was quashed. And Honorable Court directed, hear the matter and pass the necessary orders. They heard and they said, no, he is not the PT, but I am the PT who is the OP number 6 in this present petitions. That, my lords, I wanted to say, so page 76, my lords. The page 77, my lords. 76, 77, the necessary para is 76. Did my lord get it? Sir. After hearing the parties at length and perusing the relevant records, we find that a relevant aspect was not properly looked into by the DPI. All the records should have been verified by the DPI properly, and the parties should have been provided with the opposite parties to adduce evidence and hearing before taking the decision and passing the order annexure 4. Under such circumstances, we set aside the order dated 24/11/95 of the director, DPI, and direct the Director of Higher Education to consider the inquiry afresh and dispose of the same within a period of 3 months from the date of receipt of these orders. The Director of Higher Education shall bear in mind that we have expressed no opinion on the merit of the claim of any of the parties, and he is to decide the same strictly in accordance with the law and on proper appreciation of evidence. It adduced on the proper verification of relevant records and statements of the parties. If they or any of them do not adduce evidence, because the above order, we remind them, we set aside the order annexure 4 in OJC number this annexure 1, and each of OJC number this and this opposite part number 2 is free to take a decision basing on facts and evidence that should dispose of within 3 months. Petitions each of the petitions are directed to appear. So, my lords, my prayer before my lord is the order which had directed that the appellant is the real PT was cancelled, was set aside, and again that was the same order is to be passed with the DPI, and the DPI passed that I am the real OP, I am the real PT, and he is not the real PT. So that order is to be remained. And I approached my lords again. My lords, I pray my lords to kindly see who am I. 87, my lords. 87, my lords.
All this on that day you have already argued.
Yes, my lords. Only I want to show my lords what I am very sorry to say.
No, but since you have already argued, since you
just a difference, just one difference. He says he has been appointed. I say he has not been appointed. So that is only page 87. Page 87, my lords.
I am seeing it.
Page 87. Thirtieth 1086. Letter number 25. My letter number 25. I have been issued to 13/10/86 Ramakrishna Mahakur, myself. But his appointment does not contain any number of the letters. So he has not been appointed.
Sir, these things already you have argued. Why should I waste my time in this hearing it again, sir?
My lords, I will not disturb my lords.
You have argued it. You argued. When I closed it, you said that you are not given an opportunity. That is why again I granted you that.
My lords, I will not go further because
no. You said I have granted you opportunity, very full opportunity, sir.
Yes,
at
only
this court nobody should.
No, my lords, I have granted opportunity for 2 reasons. One is that he shows any investigation, he has done it. He has not done
that
any.
Part is over. That part is over.
Oh.
So since on the last occasion there was a question was raised with regard to the method of appointment.
Method.
So now you have produced the additional affidavit. Kali say ये तो दे दूँ.
I accept.
ये पूरा खबर का सब पूरा दे दूँ.
हम जहाँ अच्छी मौके दे दे कौन.
That's all.
ଟିକେ କଣ
ଆଉ କଣ
ଆଉ repeat କରିବିନି କିଛି କେବଳ your lordship will just take note of my learned seniors annexure B/4 at page 72.
B by?
B by 4. That counter which has filed.
That is it.
Again, principle, where there is an admission that CHSC की भी वो ना पठाए.
No, sir, ठीक है, but I will say that since both of you have argued extensively,
Again.
I will close it. I will grant you opportunity to file a note, detailed note. Detailed, not very lengthy, but only touching the bullet
So
points.
ଗୋଟେ କଥା ହଉଛି ଏ ଯୋଉ ଗୋଟେ select list ଦେଇଛନ୍ତି, if your lordship could take up this additional affidavit, my learned friend has filed.
Yes.
Annexure F by 4.
A by 4. Yes.
Status, sir, if your lordship would see the left-hand side, recommendation of the selecting committee.
Yes.
There is a recommendation, but there's no signature. There's a signature by the expert. The selection committee does not
The
sign
red
it.
court will enter into all these things.
No, sir. I'm just pointing out. And interestingly, his application.
This being a statutory
Again.
proceeding,
No,
this court will only look at the order of the DPI to find out whether there is any serious infirmities so as to persuade this court to interfere.
Correct.
It will be very difficult. The court will
I'll not, and on my request, your lordship have called for the OJC 1289 of 1996, where a counter was filed by the state, reiterating whatever has been given by the principal addressed to the DPI. That is his document annexed to his.
And he has also filed the original documents also, which are already on record.
Again,
He has filed it by way of
say B by 4 is जो CHSC कथाटा कहउचंती, the learned state council in this counter has also reiterated the same thing.
We'll see.
And your lordship have called for that file, that is WPC 1289.
All right.
Again, my learned friend has given a bunch of resolutions. There at page 112, at 5th agenda, it contains the name of the petitioner and the resolutions committee's decision that have been approved.
You see, Mr. Patnaik is not saying that you were not engaged. You were engaged.
Sir.
But in a temporary capacity, that is his stand. When he had been deputed for training,
Yes,
during that period you were there.
But you only appreciate what had happened in the first stage. Of course, that particular order does not survive. The specific conclusion of the DPI was that I was the first qualified PET to be appointed. Because my qualification was in 1987. Subsequently, my learned friend's client, OP number 6, was relieved sometimes in 89. He obtained that PET qualification in 1990. So I continued in the post for this period of time. Averment was also made that I was shown in the acquaintance register. I was shown in that payment register name because they had an intention of adjusting me in future in a +3 college. But the fact remains, my lord, that I was the first qualified PET, having obtained my PET qualification in 87.
Hearing concluded. Judgment reserved. Parties may file their note of submissions and memo of citations, if any, within a week. But this note of submission should not be very voluminous. It should be only brief. Only point खाली touch कर देवे. Annex को refer कर देवे so that I will be. It will be.
It's difficult. Your lordship is kind enough to allow me to inspect those records. The page number mention करते. So सोहे बार जो कोई चलती. They do not mention whether I was temporarily appointed.
But it will be better if you refer to the annexures because your pagination might not be the same as the pagination of the court record.
That this pagination is given in the records which was produced by my learned friend.
Yes.
So that was in 88. So had it been a temporary, because he was relieved, my lord, sometimes in 89. So 1 year prior to that, I can't be appointed, my lord, on a temporary basis.
All I will see. Yes.
Just not
Sorry, my lords.
15.
Difficulties by repeating the matters.
No.
मैं just pray. गुट्टे सप्ताह भीतर है.
1 week more time दीजिए. होगा नहीं?
हाँ.
1 week दे देते हो.
It's too
Mr. Patnaik, within 1 week if you want to file your note.
Yes.
There's already a note filed by me. I'll give an additional note. Okay. Obliged.
Item 4.
Item number 4.
Thank you.
Yes,
Correct pagination of the consolidated rate application.
My lord directed on last occasion to give the correct pagination that he has given and given a copy to me.
Yes, all documents.
And director my lord also directed the section to correctly paginate the entire brief. That is
से
my
देइलो
lord's-
ଥିଲେ से देइखा दउचंते से ऑफिस केमति करिवे से देइखा दउचंते
हाँ, से 5 को आसो कि 9 को आसो जब करिवे ପାଞ୍ଚ ତାରିଖ ନହେଲେ 9 ତାରିଖ 5 ତାରିଖ ସୁଦ୍ଧା ଯଦି କରିପାରିବେ ଅଫିସ ତ ଠିକ ଅଛି ନହେଲେ 9 ତାରିଖ
Learned counsel for the petitioner files the correctly paginated consolidated writ petition in court after serving copy on the other side. Office to paginate the brief accordingly. List this matter on 8th August.
5th ରେ କରିପାରିବେ ଯଦି 9 ତାରିଖ ଆସୁ
8th 8 ତାରିଖ
ଏଠି ଅଲଗା କାମ ଅଛି 9 ତାରିଖ ନାହିଁ
ଆମର ଏଇଠି ଆଜି ଯୋଉ ବାର ଆର ୱିକରେ ସେଇ ବାର unless ଆପଣଙ୍କର very serious
ମେଟ୍ରୋଟା ଅଛି ତ ଅଲଗା ଭିତରେ କରିପାରିବେ ତ ଦେଖ ନହେଲେ 8 ତାରିଖ ଆସୁ
8 ତାରିଖ ଆସୁ ଦେଖିବା ଯଦି କଣ ହେବ ତାକୁ ଦିନକୁ ନବ
I don't know, 5.
The question was raised on that day, if I remember, whether the cause of action survives. Have you taken instructions in that regard? We'll take it up next week, no doubt. I think a case, na?
Promotion needs to be.
So because you have retired. Yeah, that is what I remember. Whether it can be, whether cause of action survives or not, we'll have to see. Okay. Yes, item 5. Item 5.
Asking for passover, your lords.
All right, pass over. Ajo, pass over. Oh, pass over.
Pursuant to your lordship's direction on 18/7,
Yes.
I have not got the instruction. If your lordship calls it next week, that would be better.
8 candidates, including the petitioner, applied for the document verification. Candidates on the okay. Tell her, ask for next week. Learned State Council requests for a short adjournment to comply with the order dated 18/7/2024. List this matter next week, or the previous order be complied with positively.
Okay.
Item 6.
Hard copy of the counter affidavit that was filed earlier in 2023, may kindly kept.
The State Council files hard copy of the counter affidavit. Filed earlier. Same be kept on record. Yes, what is this? Mr. Manti?
I have challenged the order
କଣ ହୋଇଛି?
annexure 18 wherein the direction
This court would like to know what steps have been taken for reconstitution of the managing committee. order ପଢେ ମୁଁ ପଢିଛି order ମୁଁ ଜାଣିବି. The term of which is said to have already further. What is the present status of the institution insofar as the disturbances are concerned? The State Council shall apprise the court accordingly. Yes. A detailed order was passed on the last occasion, 11/7/2024.
item 6 Imagine Senapati.
Sir, my orders are not being complied with.
No, in fact, they had some difficulty.
What difficulty, sir?
This may be called on Monday. I will see that it is.
Yeah, was any communication made to the district education officer?
Yes, yes.
Then why has he not complied with that order? କେବେ communication ହେଇଛି ତ କହିଲେ?
On 11/7.
11/7. ନା 11/7 ରେ ଆମର order ଟା pass ହେଲା. ସେଇଦିନ ଦେଇଛନ୍ତି ଆପଣ?
In fact, I had talked to him telephonically.
ଚିଠି ଯାଇଛି କି?
Chithi ଆଉ that was the last letter. 11/7, 12/7 was the last letter.
Yes.
After 11
So 11/7 this order was passed and he has not replied.
He has not replied. Let me see if he has any difficulty.
Now, how was this letter communicated? By mail?
Yes.
By mail. Let him file an affidavit why contempt shall not be drawn up against him.
Let one chance.
So how should I give chance, Mr. Das? 11/7. Today we are on the 1st of August. Sufficient opportunities have been given.
Yes, I admit there have been left.
And he will ignore the letter of the Advocate General,
That should not have happened.
which contains an order direction of this court. But a completely, absolutely, with a lackadaisical approach.
So one more chance.
No, he will file an affidavit. Why action should not be taken against him? What is this? What is this? And absolutely no regard for the institution.
Should not.
Learned State Council informs that the directions of this court contained in order dated 11/7/2024, you are duly communicated to the District Education Officer Mayurbhanj,
Yes.
Mayurbhanj, by email sent on 12/7/2024, asking him to furnish the required information. The District Education Officer has not responded till date. This is not acceptable. Let the District Education Officer remain present before this court on the next date and file an affidavit explaining why he had not furnished the required information to the State Council as required by the court. Further, he shall also list this matter next week, 8th August, on which date the District Education Officer Mayurbhanj shall remain present in the court and file the required affidavit. Yes.
At note 7. Madam, the petitioner prayed for a placement in under career advancement scale in the reader scale due to a non-submission of the CCR of the petitioner by the OP number 3, and they have filed counter matter already. Other day, I filed a rejoinder matter.
What is their counter?
I have received a rejoinder copy, my lord. On this is 29/7/2024. 2 days back, my lord, that has been received. But my submission, my lord, as your lordship pointed out, what is my counter, my lord? Lordship may come to my counter. I have enclosed one copy, my lord. There is a direction from the director. That is
Due to non-submission of CCR for the period from 1998 to 39/2000.
yes, ma'am. So my lord, lordship may come to page number 9, my lord, of my counter.
Page number 9 of this is the page number 9.
Yes, ma'am. Yes.
I've seen
It
the
has been alleged by the petitioner that the placement of the placement to the post of the reader has not been considered due to non-submission of CCR for the period so and so by the concerned authority. As such, you are requested to furnish the proposal afresh, along with all ancillary documents enclosing the CCS for the relevant period to this date, to this directorate for taking necessary action. If the CCS for the said period have not been maintained, a non-maintenance certificate may be furnished there. My lord, that is what, my lord, while relying upon this particular document, we have stated in our counter, my lord, that though this was the direction, but in the college, my lord, there is no such document which is presently available to show what is the next steps what they had taken after this annexure by A/3. No document is readily traceable.
to a person will suffer for the lapses of the college.
No, may I pray, my lord, that this order of annexure A/3, which was not yet been taken care of, that has not been carried out, my lord. The lordship may direct that the case of the petition is to be considered with the stipulated period.
Yes. Yes, what do you say?
Yes, my lord.
Because
This order, this only says that if there are CCRs, they may be furnished. If there are no CCRs, then non-maintenance certificate is to be issued.
Yes.
CCR was not maintained for such and such period.
Already, page 11 and para 11, 12, they have admitted.
yes, that is what, my lord, I am saying.
So simple prayer is this, why keep it pending for since 2011?
11.
They, when
Lordship has served notice upon them since 11. They did not file counter.
my lord, for the first
And the
time, my lord,
judgment covered by similar CCR, career advancement scale, and non-availability of the CCR. This Hon'Ble Court.
The problem is your claim has not been rejected,
Mine.
has not been considered. Tale it applicable hitanga.
Mine.
No. So they will take, I will direct them to take a decision upon this. The petitioner has approached this court with the following prayer. The facts of the case lie in a narrow compass. The petitioner was appointed as a lecturer in Dhamnagar College. Which discipline?
English lesson.
Lecturer
in English.
in English in Dhamnagar College on 1/8/1978. So His services were approved on 1/6/1982 for payment of full salary cost in the UGC scale of pay. He was transferred to SG College, Jajpur, where he served from 1991 to 1997. He was again transferred to Dhamnagar College in October 1997. While serving in the SG College at Jajpur, his CCRs required for consideration of his case for grant of career advancement scale, such as senior lecturer and selection grade bracketed reader scale, were not forwarded, not transmitted to Dhamnagar College. So, it is the case of the petitioner that, as per the rules, he is entitled to be granted the career advancement scale in the year 1999, but for want of CCRs,
reader scale.
see, career advancement college is dita ta dirtha. Gotela senior lecturer scale, saparotela reader scale, ba jota ko selection grade boli bi ko jaye. Since career advancement ko it means both. Kौन लिखेगा? 99 CCRs for the relevant period. The petitioner's repeated requests and representations in this regard did not evoke any response. In the counter affidavit filed by the state opposite party, a document has been enclosed, which is a letter of the Deputy Director, SCH Orissa, addressed to the principal, Dhamnagar College, on 12/10/2011. Requesting for furnishing the CCR of the petitioner for the period from 1998 to 39/2000, or a non-maintenance certificate. No action appears to have been taken on such letter, on such a request of the request so far. Who is appearing for the college?
My lord, I have filed that count.
Who is appearing for the college?
College means, my lord.
College.
Opposite party
By
number
the
3.
opposite party number 3, my lord, I have filed the count. Because he has been authorized by the director
All.
and the secretary to file.
In view of such facts, nothing remains to be decided in the writ application, save and except directing the concerned authorities to act upon the letter dated 12/10/2011 of the Directorate of Higher Education. Stop. The writ application is therefore disposed of, directing
Opposite party number 3.
opposite party number 3 to transmit the CCR of the petitioner for the relevant period, that is, period of 1998 to 39/2000 to the office of the director as early as possible, preferably within a period of 2 months from today. Stop. Upon receipt of the CCRs, the director, opposite party number 2, shall consider the case of the petitioner for grant of reader scale of pay as was as has been granted to persons similarly situated like him. Decision in such regard shall be taken by the director within 2 months from the date of receipt of the CCRs. That's all.
May I comment? Instead of, I'm making a prayer, my lord. Instead of directing the authority to furnish the CCR for the relevant period, because it has not been maintained.
CCR or non-maintenance certificate.
May
I'll say.
may I pray, my lord, to comply by furnishing the fresh proposal as it has been submitted, directed, my lord, with respect to omitting this particular period of CCR, my lord, so that, my lord, the 5 years CCR, it can be sent, omitting this particular period of CCR. By the, so that it can be.
The director, the opposite partner with the principal is directed to transmit the CCRs that are maintained, and by omitting the period during which CCRs were not maintained, to the director as early as possible, preferably within 2 weeks.
Already,
Data कर दूँ. Data कर दूँ.
अब खाली रिपोर्ट है CCRs along with the required proposal. CCRs along with the required proposal. ସେଇଟା ଦେବା ପାଇଁ ତାଙ୍କୁ କୁହାଯାଇଥିଲା ଯୋଉଟା ଦେଇନାହାନ୍ତି.
minor check period already they have sent.
ପରେ ଏଇ ଲେଟରଟା
Not maintained. Along with the proposal for grant of reader scale of pay
Yes, ma'am.
to the petitioner. No, to the officer. From today. Tapare. Upon receipt of the CCR slash proposal.
Has been granted to persons similarly situated like him. Decision in such regard is taken by the director within 2 months from the date of receipt of the CCRs and the last proposal.
Super honor Annexure 10 at page 40. Relevant is page 41, page 42, where it also says please to direct. Third paragraph is small one. Keeping in view the limited grievance of the petitioner, this court disposes of the writ petition without expressing any opinion on the merits of the case of the petitioner. The opposite party number 2 is hereby directed to examine the case of the petitioner, and after affording reasonable opportunity of petition hearing of the petitioner, shall take a decision strictly in accordance with the merit of the said representation within a period of such and such time. So my representation did contain minus 3 clauses. One is I was appointed as an Anganwadi worker. After attaining graduation qualification, I was posted as an Anganwadi supervisor, as then the rule was prevailing. There was a cadre list. In the cadre list, my senior number, I may say it a gradation list. Though I was posted to a junior cadre posting later on. My serial number was 1. Then the authorities posted me in the year 2010, prior to me, just 1 second, Manus, prior to me, further appointments were made in the post of supervisors on being promoted. That was in the year 2008. Now, 2010, I was promoted to the post of Anganwadi supervisor to a post at Barchana in the district of Jajpur at a consolidated pay with contractual basis on the ground that I undertook such a condition placed by the government. Then in 2012, they gave further appointment to my juniors. Those juniors were in the gradation list where I was serial number 1, and thereafter the below me were placed as Anganwadi supervisors in the regular scale of pay. So we were some Anganwadi workers who were posted at Anganwadi supervisors in that phase were just given a contractual appointment with a consolidated pay. Our grievance before the collector was
whether our such a posting can ever be treated to be contractual when the rules prescribed no contractual appointment, because there is a specified rules governing the field to place Anganwadi workers to the post of Anganwadi supervisors. Second grievance of ours was, mine was, whether can I ever be accommodated with a consolidated scale of pay when I am rendering the equal work as those persons in the regular establishment. Now the collector disposes of my representation, which is Annexure 11 before Lordship's brief, that is at page 43.
KCT पछाडि सब बस्छु मोबाइल धर्छु त्यहाँ कोड बाहर जो अपिङ छ नहीं से जारा लोक नहीं see the man no next to him yes तांकर मोबाइल बाजे लगी पछे
He is my legal assistant, so I take responsibility of.
he brought out a mobile from his pocket, that is what it was.
He should not have done that. With due regards, one of my matter is called in another bench, probably that is why his anxiety might have been going through the court list, if at all. That is correct. If otherwise, then that is a misdemeanor.
Keeping it on vibrate mode will do, sir.
Probably he was looking at the court.
No. There was a sound, that is why.
Any event, vibration or non-vibration.
There was a sound, that is why I was.
Is bad.
Doesn't matter.
Yes, madam. That is bad.
Yes.
And not to be tolerated at all.
Anyway, so you were granted contractual appointment.
Yes, my lords. Then if I beg your lordships to kindly go through Annexure 11, page 43, where the representation was dealt with by the collector, my appointing authority. That is an order dated 21st of March 2013. Could your lordship get it? I take your lordships to third paragraph. There has been certain discussions. I skipped the first 5 lines, but I beg before your lordship to read though. There is the representation dated such and such of the petitioner. The petitioner has submitted that as per this direction of government, such and such department, right?
You are reading from which page?
Page 43 of your lordship's brief,
Yes,
Annexure 11. Good lordship, get it?
Yes.
I am reading the third paragraph, my lords. The first paragraph being a single line.
Yes.
Then I take your lordships to the peruse the representation. Could your lordship get it? Dated
yes.
Such and such of the petitioner. The petitioner has submitted that as per direction of government such and such. Number such and such gradation list of graduate Anganwadi workers with a seniority of minimum 5 years working in the district was prepared for filling up the post of ICDS supervisors on contractual basis, wherein the value of the petitioner is at serial number 1. Thereafter, the petitioner was appointed as ICDS supervisor on contractual basis by such and such order dated such and such, on submission of no objection to accept a contractual post and with undertaking not to claim regular scale and other allowances during her contractual appointment, was relieved by such and such dated such and such from Minjapur to report for duty in her new assignment while the petitioner was continuing as such government in Women and Child Development Department, communicated the sanction of the governor to the creation of 38 number of ICDS supervisors in respect of Jajpur district in 3 phases for filling a vacant post of ICDS supervisors in Jajpur district. Here, if I beg before lordship to kindly take a pause, here my appointing authority clearly discloses that 38 posts in the government were created where I was adjusted, my lords.
They managed to obtain no objection from you also.
They have taken no objection.
Whether it is binding or not is a different matter, but this is also a fact. All it.
So I had no other option, my lord, than to put my signatures on the papers that they provide. Then I take your also to second paragraph. Thereafter, in pursuant to the notification number such and such issued by the government in such and department, 9 Anganwadi workers of Jajpur district were promoted to the post of supervisors as against the vacant post by order dated such and such of 2011. While selecting candidature from among the Anganwadi workers of Jajpur district for their promotion to ICTS supervisors, the provisions of Rule 8 of Odisha Children Women Welfare Service Rules 1989 and Rule 4 of the Odisha Children's and Women's Welfare Service Amendment Rules 2007 not been properly followed, for which the present petitioner has been prejudiced from a legitimate claim of being promoted to the post of ICTS supervisors, although some of her juniors have been allowed to be promoted to the said post. There is the submission of the DSWO Jajpur fighter letter number such and such. She has submitted that the present petitioner accepted the contractual appointment in the said post of ICTS supervisors by submitting no objection for such appointment and an undertaking wherein she has undertaken that she shall not claim regular scale and allowance for continuing in the said post. As such, her name has been eliminated from the gradation list and her case has not been accounted for during the process of promotion to the post of ICTS supervisor. The DSWO Jajpur has not challenged the eligibility of the present petitioner for promotion to the post of ICTS supervisors as per the eligibility criteria provided under the rules, which leads to the assumption that the present petitioner is eligible for promotion to the post of ICTS supervisor. Now the findings matters. Secondly, as it appears, accepting contractual appointment in the post of ICTS supervisors by furnishing a no objection for such appointment and an undertaking not to claim regular.
Whoever is the collector has given a fantastic. Absolutely. I have read it entirely. Mr. Das.
I'm thankful, madam.
I have read it.
Yes.
The last paragraph is very relevant. He says that in view of the facts discussed above, this court is inclined to hold that the present petitioner has been prejudiced of a legitimate claim of being promoted to the post of ICTS supervisor only because of misrepresentation of fact during the selection of candidates from among the eligible. Presumption beyond the existing statute should not have been encouraged. This is exactly what struck my mind when I was going through. This is he has himself written.
I'm grateful.
Even if she has submitted a no objection, whatever the statute says will prevail.
Yes, that is definitely.
There can be no. I mean, she cannot override the statute, even if she submits a. Yes. Now, what happened? So this order is in your favor.
And thereafter, my lords, they allowed the only pressurized me to continue in the consolidated scale.
No, this order is there. This order is in your favor.
Yes.
So what happened then? Why did you come to this later?
Because I was only pushed into the status quo status.
No. What was the cause of action?
Cause of action, they did not pay me.
Implement this order.
No, your lordship sees the last line. There actually, I was put into the corner.
With a direction to the DSW Jajpur to obtain clarification.
Concludes the instant proceeding with a direction to the DSW Jajpur to obtain clarification of government regarding the eligibility of the Anganwadi workers appointed as contractual basis in the said post of ICTS supervisors for promotion to the said post under the existing rules and reconsider the case of the present petitioner. It was not considered. And I continued and I am still continuing in a contractual pay.
No, it means this has not been taken to its logical conclusion.
Yes.
So the government should have taken a decision. They should have, the ICTS or the DSW should have written to the government.
Yes.
So no, nothing is necessary. It is no longer necessary to write to the government. Yes, Mr. Das, what is your counter?
Further affidavit has been filed after the counter affidavit was filed. Referring to the further affidavit dated.
What have you said that?
There is judgment of this honorable court has been referred to and
your lordship may receipt at flag B 87 pages of your lordship's brief if it is designated. 87 of your lordship.
I am looking at it. What is their stand?
Their stand is.
Let us see what is the clarification.
Number one, the government has brought in another rule in 2014. By virtue of which the promotion to the post of Anganwadi supervisors from Anganwadi workers is not available. So now I cannot be given back a regularization of my promotion as I got in 2010.
No, but you were considered under the earlier rules.
Yes. That is one of their ground. Then second ground, my lords. So they say there has been a judgment of this honorable court passed in a writ petition.
That is in the further affidavit.
That is in the further affidavit, your lordship sees at page 93.
Yes, I've seen it.
Yes.
They say
There,
that
my lords.
if the post is created on contractual basis, then you have no right for
Yes. Yes, ma'am. That is why before I was just in the collector's representation, I took a pause to submit before lordship that the collector has found out that 38 posts have been created. So the judgment which my learned senior refers on being supplied by the government, there this honorable court could come to a conclusion that the posts in Malkangiri district were specifically created on a temporary status as Hon'Ble supervisor, somewhere given appointment. They came up before your lordship that we need to be regularized.
that was rejected.
That was rejected because the posts were created temporarily.
No,
Here
but-
the collector comes to a finding that 38 posts have been already created in the Jaspur district, and against one of such posts I was appointed.
No, but the fact remains, you have also enclosed that order,
Yes,
that 85 rural ICDS project of Mangola.
yes.
Annexure 12 to your additional affidavit.
And I'm grateful, my lords.
No, but the fact is, when the petitioner was appointed as a supervisor, there were certain rules in place.
Yes.
So she should have been appointed as per the rules,
But
which
he was
the collector has practically found. But instead of finally, passing an order, he somehow passed the buck. Negi. Suppose ठीक थिले,
But she was
See,
given the
अगर-
contractual appointment.
ठीक है
That-
कि- Anyway, so the government never clarified.
No.
I don't know whether the DSW sought for a clarification with the government as directed by the
That
collector.
is
or
of
not.
course not there on record.
No, this court would like to know that.
If I beg your lordship kindly to see annexure 12, as your lordship did, please to
Mr.
go
Das,
through
we
that.
have,
I'm grateful,
Mr. Das,
my lords.
let us go in a sequence.
My
You know,
lords.
the collector's order is there.
Yes,
That is your trump card.
yes,
Now, the collector's order has to be complied with
yes, ma'am.
by seeking clarification from the government.
Yes,
No, but here from the counter affidavit, what we have find they have tried to develop their case in an entirely different line. They have referred to the new rules.
in the counter affidavit.
Yes,
Yes.
they have referred to the new rules. And accordingly, they have they have given some
Yes, ma'am.
clarification.
And that her appointment was contractual and she had accepted the same.
No, see, that is, of course, we'll look at the rules and particularly when the posts are created.
Yes.
So we'll keep it part of you prepare. Find out.
And
Irrespective of whatever affidavit or further affidavit you may have filed and whatever stand you may have taken,
What consideration was
but the
given?
first fact remains that there were certain rules in place. She was appointed pursuant to those rules. So it could not have been dehorsed the rules. That is one part. Second part, the collector has also held so.
Provided it was under that rule, but
That
now.
find out. That we have to find out.
in
Because that was in
2010,
2013,
my promotion was 2010, my lord.
2010. That is an admitted fact.
Yes.
Now the collector holds all these things.
And
for
can
some
there be a
reason-
contractual
No,
promotion, my lord?
for some reason, he concludes the proceeding with a direction to DSW to Jajpur to obtain clarification.
He should have directly got it.
He should have directly passed that order.
Yes.
I'll just keep it parted. If necessary, I'll modify this order of the collector. If this is your finding, then the natural corollary of it is that you have to direct them to appoint.
Yes.
If this is your finding,
And the government be directed to consider pursuant to this, since the collector has passed on the buck to the district education officer, your lordship.
no, I will decide it
Social
here.
welfare officer.
Mr. Das, I think we can decide it here instead of relegating the litigant to another round of running from pillar to post.
No,
We'll decide it here.
decision has to be taken by at the government level. In case of this petition.
So the government will take a decision. We will direct the government to take a decision.
No, that direction be issued, let them take in
What do
case
you say,
of this.
Mr. Das?
As your lordship do.
No. You consider whether it will inure to the benefit of your client or not. Because this,
Because my client retires within a couple of months. She is touching 60 now in the month of October. Then I take your lordship and your lordship, I will just take one line submission subject to lordship's
Yes.
approval. Page 110. I take your lordships to serial number 48.
No, you have to refer to, the pagination is not matching.
Annexure 12, as your lordships did submit.
So tell me Annexure 12.
Annexure 12, in my additional affidavit, if my page doesn't match your lordship's brief, then I will correct it.
This is of 1997. The posts were created.
Yes, 1997, I take your lordships to serial number 48. That is in the district of Jajpur, Bodhgana. Would your lordship get it?
Jajpur.
Third page.
Yes, I got it. Jajpur, Rasulpur, Bori.
9 Anganwadi supervisors were created in 1997.
Mr. Das, you are referring to
Column 1, column 2, my lords.
Your additional affidavit.
Additional affidavit, Annexure 12, your lordship got it, 1997, that is the order dated 17th of February, 1997.
Jajpur begins with this Bodhgana.
Jajpur begins with, my lords, Brosoma, Ersoma. Jagatsinghpur, then Jajpur begins with Bodhgana, 48.
Bodhgana.
Yes.
48.
1, the first column, second column is 9. Second column is the supervisor.
Supervisor.
First column is CDPO.
Yes.
Then 1997, 9 supervisor posts are available at Bodhgana and I have been posted at Bodhgana. Before me, all got regularized and they got regular scale of pay. I am the only one, black cat among all them, and I have been paying contractually. And after me, 9 posts are all vacant. They're all filled up now. I am the only one and another 2%, 3. Leaving aside them, all 6 as on date are getting regular scale up. So these 9 posts, they cannot say they have been contractually created and are being filled up.
No, there is nothing to show that they were contractually created.
No. And the collector's decision, I just stopped there for a moment because to apprise your lordship that 38 posts of Anganwadi supervisors in the Jajpur district were created. So when the posts are created, there cannot be a tag of contractual status. And the rules that they follow.
Come to Annexure D by 3.
D by 3, my lord.
D by 3 to the counter, which is at page 62 probably. 62.
That is 111108.
Yes.
Yes, madam.
As against this, you were called, the option was called for from you.
Yes.
There was a written undertaking.
Yes.
And on that basis, you were.
And this is how far can it be ever sustainable, madam?
That is one part. Second part, if this is applied against in respect of your candidature, what about the others who have
other candidates who have been appointed subsequently, my lord? That is, that is my annexure at Annexure 8, page 33.
Of the writ petition.
Of the writ petition.
Annexure 8.
That is in 2011.
Yes.
Annexure 8, page 33. All they were regular appointment. And some of them are matriculates. I am graduate supervisor, graduate Anganwadi.
All right, Mr. Das, you prepare, we'll continue next week. Or in part places.
Or may I suggest your lordship may direct in view of that order of the collector, let the government take within a particular time.
What do you say, Mr. Das?
If your lordship passes that road, but I am afraid since I have been running since 2010, it is 14 years since. And once I am retired, then I am thrown out of that. And Anganwadi supervisor. If my learned senior takes up the responsibility, then I am sure that something will happen.
The responsibility government will take. How can I?
Naturally, and you are an officer of the court as well as responsible.
No, let us hear it and finally decide.
Yeah, that would.
Next week, let us finally decide. You prepare. You see, there are 2-3 things. Even on creation of the post, and the posts are not contractual. They're regular posts. 9 vacancies are available.
He had given an undertaking.
So that undertaking, what is the sanctity of that undertaking? And that the collector has already decided.
Yes.
This court need not further reiterate.
Yes.
The only thing is that having held so, the collector then should have, put an end to the matter. Instead of doing it, he asks the DSWO to and obtain clarification from the government.
And in 2010, the rule which was applicable, it prescribes that how and when this post can be filled up. That is not a single whisper regarding contractual appointment, or it's a junior cadre post, my lords. If it is a junior cadre post declared by the rules, how can it be promotion post contractual?
No, let him prepare that. Let him prepare. But in part, let's just matter next week.
9th August.
9th August.
I don't know,
Yes,
9. Next, please, Your Lordship.
And in this case, my lord, the petitioner was appointed as a ASA worker under Sukinda Gram Panchayat bylaw. After working for 10 months, he was issued with a disengagement order that is at Annex 4, page
You filed your counter?
No counter.
The last occasion you said that you had received your Paravez comments.
Yes. Was pre-filed, not filed.
Before your lordship takes up the case, my
Yes,
unconditional
correct.
apology because the mobile of my chamber disturbed your lordship.
Doesn't matter, doesn't matter. No, I'll tell you why. Mobile when he brought it out again from his pocket and started doing something.
That
So
is not becoming.
I thought that he's some outsider. That is why I asked him to go out. Court is mine.
Sir, though I had taken time on the last occasion, but it could not be filed. One more chance may be given. It has been received. The Paravez
I'll
comment.
keep it to next week. You file your counter in the meantime.
Yes.
This matter next week as paid for. Counter affidavit will be filed in the meantime positively.
I don't know, 10.
Right, in this case, my lord, on 11/7/2024, there was a direction to me, my lord, to file the counter.
Yes.
I have received a Paravez comment from the CDM cum PHO. But, my lord, in fact, the impugned order of the washing that sort, cancelling that selection process has been passed by the collector, my lord. So the Paravez comment which I have received, my lord, in the meantime, my lord, that is, I received on 29/7/2024. I found that, my lord, that is to be inadequate, my lord. So may I pray, my lord, for some time, my lord. 2 weeks time, I have positively, my lord.
Submits that he has received the Paravez comments, but the same is inadequate to prepare the counter. As such, he has sought for further instructions. Let this matter go to week for
22nd August.
on 22nd August. Counter affidavit will be filed in the meantime.
22nd August.
Yes.
Item 11.
What
Right
has happened
to the
in this
lordship.
case?
This is a matter in lordship, disengagement of Jogano Sayak, my lord. The petitioner was appointed.
Pleadings complete.
No, my lord friend had taken time to file a rejoinder.
No, I have filed
You filed a rejoinder?
I have filed the written note submission. Rejoinder is not required, my lord.
Not required.
Not required, my lord.
Then give you a return note to him.
Yes, I have.
You have given?
Yes, I have filed in the count. My lord, why the rejoinder is not required? Because in the counter they have come up with the new allegations. The fact of the matter is that.
Hey, what is your prayer?
My prayer is that engagement, my lord. I have
You
been
are disengaged as Jogana Sayak.
As Jogana Sayak.
Jogana Sayak is not appellable. Not appellable.
No, ma'am. No, ma'am.
I am always confused with grammar of Sebek and Jogana Sayak. Anyway, so this is
In 2017.
You were disengaged.
I was disengaged. I don't know when I was disengaged. The fact of the matter is that in 2017 I was being appointed. In 2022 I took a sick leave, my lord. And when I was on leave. After taking the completing the leave period, when I went for resuming my duty,
you were not allowed.
They did not allow me. They prevented me to work.
Okay, then
they asked me to the medical report, the certificate. Annexure for 14 I gave to them. And medical report, they inquired about my case and then they recommended that it's a genuine case and he should be allowed to work. Thereafter, my lord, I repeatedly successive representations I gave to them, but they did not allow. Thereafter, I was constrained to come before this honorable court, and this honorable court directed me directed the opposite parties to supply me why I was not being appointed till date. Thereafter, they came up with the allegations of corruption. And in the counter, for the first time in this court, I came to know that during the period, such a long period, I was from 2022 to 2023 and more than about a year, I was not being allowed, I was prevented to work. And during that period, such allegations had come. I was not present at all. In the annexed counter affidavit.
There was some inquiry, some fact-finding inquiry, but he was never heard. He was
Yes,
never given any opportunity of hearing.
And
In fact, the BDO
Annexed-
had made allegation against him.
No, there seems to be a joint inquiry report which you have enclosed.
Yes,
My
As
lord,
annexure B by, just,
yes, my
B by 5.
I'm speaking in your favor, sir.
sure.
I'm always reminded when I was a young lawyer, before Justice Pradeep Rai and Justice R.K. Patra probably, the old court number 5. I was making a submission when Justice Pradeep Rai told me that when the court is speaking in your favor, you should keep quiet. I'm trying to find out because
Sir.
so whatever happened prior to the his going on medical leave, and he went on medical leave, which was found to be correct, and a certificate was obtained. That part is taken care of. Subsequently, in your counter, you have come up with this corruption allegation, and it seems to have been inquired. There was a joint inquiry. Was he part of this on the inquiry?
No.
That of course has not been
That's all.
reflected.
My lord, just I want to come to that point, my lord. In the annexure A by 5, page 9 of the counter, that is the complaint, where there is no date also is mentioned, man.
All right, but in
That is
any
one
case, it was inquired into. Annexure B by 5. BDO has that there's a joint inquiry by PEO, then
4 or 5 people were there.
yes, GPO, ABDO, IS, all have inquired.
And the inquiry report in the final line, they have mentioned the allegations that I was demanding bribe. And the number of the people that 127.
No, we come to the last part. As per the statement of the above petitioners, they demanded bribe.
Yes.
And accordingly, on that basis alone, he has not been given any opportunity. Has he been given any opportunity?
Of course, that doesn't
Also,
appear
my
on
lord.
B by 5.
In all the names they have signed, some people have mentioned 700, some people even have not
Sir,
mentioned.
why are you going to the merits?
My lord,
Why are you going to the merit? Whether you have been granted any opportunity of hearing or not.
not at all, man.
That is the only case. Why should the High Court enter into the factual
Yes,
aspect?
yes, man.
What do you say, Mr. Das?
You'll also may ask them to give them an
Yes, we'll
opportunity.
reject it. We'll set it aside and we'll ask them to, if they have any material to conduct an inquiry, let them conduct, but he should be given opportunity.
Yes.
And he should be reinstated immediately.
Yes, man.
Yes, what do you say?
That as your lordship would direct.
No,
Already 2 years, my
if
lord.
that order of disengagement goes, and that order of disengagement is enclosed as
Annexure 17, man. 17
Annexure
series.
17 series. And that was also never communicated to him.
Yes, man.
All right. The petitioner has approached this court with the following prayer. The case of the petitioner is that he was engaged as Jogan Sahayak under Birikot Gram Panchayat in the district of Gajapati with effect from কেবে সেটা 2/11/2016 বলে 2/11/2016 তো
Engaged.
হ্যাঁ
I was engaged. 13/9/2017. I was engaged.
No, sir.
Disengagement.
I was appointed on 13/9/2017, man.
Okay. While working as such, he remained on leave. He remained on medical leave. After recovering from his illness, when he wanted to join, he was not allowed to do so. Subsequently, however, papers were sent to the CDM and PHO, Parlakamudi, for verifying for verifying their veracity and genuineness. The CDM and PHO certified that he is cut off. Subsequently, when he wanted to join, he was not allowed to do so. On production of a medical certificate by the petitioner, he was asked to appear before the medical board. The medical board found that the medical documents produced by the petitioner were genuine, and accordingly they recommended leave on medical ground. Stop. In spite of such recommendation, the petitioner was not permitted to join. Subsequently, by letter dated 12/11/2024, the Assistant Collector Bracket Judiciary informed that he had been disengaged from service on the basis of a joint inquiry conducted in respect of certain allegations leveled against him. In the counter affidavit filed by the state, it is stated that there were several allegations. There were several there was complaint of receiving of bribe, a demand of bribe by the petitioner from several beneficiaries. Accordingly, a joint inquiry committee was constituted by the Block Development Officer Mohana. The said committee conducted an inquiry and submitted its report, holding that the petitioner had demanded bribes for issuance of new RC. What is this RC?
Ration card.
For issuance of new ration card, addition of name in the existing ration card, and even for issue of PMAY house. Where is that order of disengagement? Accordingly, by order dated 19/7/2023, the CSO, the Civil Supplies Officer, Gajapati, requested the BDO to issue order of disengagement, who in turn directed the Sarpanch, Birikot GP, to issue necessary order. Accordingly, the Sarpanch, by letter dated 27/8/2023, disengaged the petitioner. Nilamban election. Again, Nilamban election. Sir,
disengaged.
Nilamban disengaged. Suspension now. Disengaged the petitioner from his post. In course of hearing, it is submitted by learned counsel to the petitioner that the impugned order was passed without granting any opportunity of hearing to the petitioner. In fact, the petitioner was also not called upon to participate in the joint inquiry held against him. The State Council submits that the inquiry was conducted because of several complaints received against the petitioner, which were found to be true. Stop. Therefore, appropriate action was taken against him. Para. The facts of the case are not disputed. Stop. It is right that when there is an allegation of misconduct by an employee, the same is to be inquired into by the concerned authority by giving proper opportunity of hearing to the said employee. In the incident case, there appears to be some complaint of demand of bribe by the petitioner, for which a joint inquiry was conducted by the PEO Birikot, IS Mohana, GPEO Mohana, and ABDO Mohana. Perusal of the joint inquiry report dated 2/2/2023, copy enclosed as annexure BUA 5, does not reveal that the petitioner's version was asked for or considered. In fact, there is nothing to show that the petitioner was ever a part of such inquiry. The principle of natural justice demand that the principles of natural justice as embodied in the maxim Audi alteram partem mandate that no one should be condemned unheard. Stop. From what has been narrated above, it is clear that the drastic step of disengaging the petitioner from service was taken without affording any opportunity to him to put forth his defense in the matter. In fact, the so-called joint inquiry, according to the considered in the right to life, guaranteed under Article 21 of the Constitution of India. Stop. As such, no person can be deprived of such right without following the due procedure of law. In such view of the matter, this court is left with no doubt that the impugned order of disengagement cannot be sustained in the eye of law. In the result, the writ application is allowed. The impugned order dated कितने से ना?
21st of August 2023.
21/8/2023, passed by the Sarpanch, Birikot Gram Panchayat, is hereby set aside. Is hereby quashed.
Yes.
The Sarpanch is directed to reinstate the petitioner in service forthwith. Stop. Forthwith, with all consequential service and financial benefits.
Okay.
Stop.
Which would be subject to if any opportunity of hearing is given and
No. Subsequent, no. As regards the allegation leveled against the petitioner, necessary inquiry may be conducted afresh, granting proper opportunity of hearing, proper opportunity of defense to the petitioner. Stop. It goes without saying that the authorities would be at liberty to take appropriate action in the matter, depending on the outcome of the inquiry.
After compliance of the principles of natural justice.
Yes.
But in the meantime, he has to be reinstated with all.
May pray your lords may direct for the postal tracking report, so it can be. And so far as the counter filed by the opposite party number 6 is concerned, I will file a rejoinder to the same.
Postal tracking report we tagged to the case record. This matter next week. Next week that we will pass that on.
I have already filed a counter ballot. So e-filing ballot I have already filed and.
Land State Council files hard copy of the counter in court after serving copy. The same be kept on record. Rejoinder we'll see. Rejoinder next week. I can see postal tracking report.
Item of 13. In this case, matter on 20th June. In this case, matter on 20th June 2024, notice was issued, matter. I have contacted the
postal tracking report says that it has been delivered. Postal tracking report shows that notice on opposite party number 5 has been duly delivered. There is, however, no appearance from the side of opposite party number 5. Yes.
But we'll file the counter ballot 2 weeks time, maybe. This is the first time ballot.
2 weeks time is allowed to the State Council to file counter. 22nd August. Is this matter on 22nd August?
Yes.
Item number 14.
Madam, on behalf of Mr. T. Prabharaj Mehta, I would requested to adjourn the matter for a week, matter. There's some personal difficulty.
All right. As requested, is this matter on? As requested by Learned Counsel of the
Said, I have searched in the address the name of Satyanarayan Martha, son of Ekadashi Martha of Mohantipoda, Patna.
You find out the correct address?
Yes, but no such person is found in the given address. The villagers and local sarpanch are saying there is no such person like him. Hence, return the notice to the honorable
record that is the correct address.
This is what the.
Will direct the court below to.
Already, my lord, 3-4 occasions have passed. It's a poor lady, my lord, having a small girl child.
See, without notice being served, how can we dispose of? There will be a technical difficulty. That cannot be done. Notice has to be served somehow. The State Council informs that the IIC of Pahada Police Station has informed that despite on inquiry in the concerned village,
if your lordship likes to.
No person by the name of the opposite party could be found. Stop. Further, the sarpanch and villagers of the said village also categorically stated that no person by the said name resides in the village. Stop. Learned Counsel for the petitioner submits that the address of the opposite party mentioned in the transfer application is the same as what has been mentioned by him in the court below.
Right.
Stop. Such being the case, the court below is directed the co-court, the family judge.
Mentioned by her. Because she is the applicant before the current family judge.
No.
No, the
husband is the
filed.
I am the respondent.
In
Family
fact, the matter,
matter.
let the judge, let the learned judge, family court 2, family court 2, Bhubaneswar. Take steps for service of copy of the transfer application on Satyanarayan Martha, the petitioner in
CP number.
In CP number 652 of 2023.
Well.
Yeah.
Well.
a copy of the transfer application along with requisites for service of notice be filed within 3 working days, which shall be transmitted to the court below by the registry. That's all.
Filed by the petitioner.
He will file it for this court. That will go to the court below. The court below how can they?
Yes.
Registry. A short returnable date be fixed. Place this matter on
30th September.
30th September.
I don't know, 16.
No, please, Lords. This case is relating to transfer of the GR case from Umarko, GMS Umarko to Nabarpur. You Lordship remember, in this case, the petitioner's wife filed an appeal, filed a case under section 490 and 307. When this honorable court directed to surrender before the learned court, when the petitioner along with his family member surrender before the learned court, the police taken out from the judicial custody, but subsequently religion bail, and when the religion and return to the home, again the wife of the petitioner attack in the roadside in along with the villagers and near relative. Therefore, the FIR is registered. Subsequently, also directed to take instruction. In the meantime, the FIR charge sheet is submitted.
FIR which the Lord charge sheet has been filed under section 341, 294, 323, 506, and on the same day, case and counter case. The opposite party also lodged a FIR under section 294, 323, 341, 354, 379, 506. That is, investigation has already completed. They had sent to SP for submission of CS. And that is under section 341, 294, 323, 354, 506. And no other case. Apart from these two cases, no other case is pending between the parties. They both lost case and counter case. Already one charge sheet has been submitted and another pending for charge sheet.
In the GR case, you are the accused.
Your Lordship, kindly see the annexure 1, page 8 matter, the first case. That is registered under section 498, 323, 307 and other offences. When this honorable court directed to surrender, we came to the court for surrender, but in the court premises, along with the complainant, convention the police authority, taken away the petitioner from the judicial custody in the court premises. But subsequently, interference of the JMFC, the police authority returned back the accused to the court, and subsequently, procedure as maintained and the petitioner released on bail. When they, at the end of the day, when they return to home, the petitioner, the residence of Malkanagiri. This is the Umarkot, 200 kilometers. Though the petitioner, the wife of the petitioner, local person, along with 15 to 10 members, the family members and the other person, block the road in when the petitioner returned to home and attacking the middle road near the police station, only 500 meters. They got information that, but now the petitioner going through road. They blocked and attacked. First FIR is 307. Subsequently, on the same day, when release on the
I understand. Don't have to repeat. Sir, don't have to repeat. I understand.
Therefore, they have to transfer the.
What can be done?
से फाइल कले ये भी subsequently PS case number 55 फाइल कले
ये फाइल करा पड़े ये फाइल कर
ये फाइल कर
same time
they are 54
there are two cases
and
my lord.
55
after being released on bail my lord they created disturbance my lord
that case also investigation almost completed and they are sent for SP to for approval for filing
all
of
these
charge.
things happen only to transfer the case my lord. That is the motive my lord, otherwise nothing is else my lord.
Yeah, on this ground, I am very slow to transfer because
Yes, my lord. And
the court can always grant protection.
Yes my lord. There is also a Supreme Court decision my lord, which I have.
No, the Supreme Court decision must be on facts.
Yes, my lord.
There is no such.
No, in similar fact, my lord, in similar situation, my lord, the Supreme Court Honorable Apex Court denied to transfer in such type of allegation.
No, I will not
It is a
transfer.
criminal
I will only say that he being the accused, he is to appear before the court.
Exactly.
Your lordship may.
No. He may be. He is on bail now.
Yes.
There is a 317 provision,
Yes, ma'am.
isn't it? You can always seek representation through your counsel unless absolutely necessary.
Only because when the petitioner go to the area, the informant, the wife of the present petitioner, They create disturbance in the attack.
No,
Therefore, subsequent FIR
no,
registered.
I will say that the court will, if you are feeling threatened, then the court will pass necessary orders for your protection. All right.
ସେମାନେ ବି disturbance create kale for
How
that.
I am from the 200 kilometers. When I returned after bail, I returned the road. They blocked the road.
Investigation already completed and
Lordship see the FIR.
it has been sent to
And the charge sheet, how it is
SP for
from the distance.
State Council has obtained instruction that in the affair launched by the present opposite party, investigation is complete and the matter has been referred to the SP for submission of charge sheet. It is stated at the bar that charge sheet has already been submitted in respect of the case lodged at the instance of the petitioner. So, as it appears, there are allegations and counter allegations relating to creating of disturbance. While the petitioner alleges that he was heckled on the road by the heckled on the road at the instance of the opposite party and her family members. Similar allegations are made on behalf of the opposite party. This court takes note of the fact that the petitioner, being an accused who is on bail, is not required to, can always take recourse to the provision or if there is any such apprehension or threat to his personal safety. Yeah. In such view of the matter, this court, while not being inclined to transfer the GR case as prayed, disposes of the application with a direction to learned JMFC Umarkot to firstly not insist upon the personal attendance of the petitioner unless absolutely necessary for the case, and secondly to pass necessary orders for his protection if any such motion, if motion to that effect is made. Yes.
Hon'Ble.
Item 17.
My lord, here in this case, the petitioner has already filed another TRPC 72 of 2024, in which I have already filed my objection. Let it come along with that TRPC 72 of 2024.
With this matter, list this matter along with TRPC number
72 of 2024.
72 of 2024 on
22nd August.
On 22nd August.
Item number 18.
Who's for the petitioner? We'll pass it over. Pass over.
Item 19.
May I please note. Lord, application for transfer of 1cc case from Nimapada to Bhubaneswar, my lords. The allegation is that, my lords, they are threatening me, my lords, and we have lodged an FIR, my lords.
19.
37 of 24.
Sit 18.
Sir, I am for 18, my lords, I'm sorry.
18 pass over. Oh, wait. What is this matter?
On this last occasion, when the lawsuit direction of the state government, we take instruction.
They got the FIR lodged by the petitioner.
Yes, already FIR has been lodged, my lord. Nayagarh PS case number 271 dated 22/7/24 under section 341, 294, 323, 506 and 34 of IPC, and the case is under investigation, my lord.
Yes. Where do you want this case to be transferred?
Transfer from lawyer family just got up from Nagarko to Kotak, my lord.
From which place?
Nagar to from Kotak.
Nagar to Kotak. Why?
Place of is 170 kilometer. My native place is Jagatsinghpur, my lord. I am working at Jabalpur as army personnel. Okay. The last occasion while I am going to appearing before this court, the incidents happened on that day, my lord.
You will appear virtually. You are in Jabalpur. How does it matter whether it is in Noaigad or any other place? You will appear virtually.
That's what the matter. I am
No,
ready to pay to and fro.
No. The petitioner seeks transfer of CRLMP number 248 of 2023, pending in the court of Learned Judge, Family Court, Noaigad, to which court?
Judge Family Court,
To the court of Judge, Family Court, Kotak. Therefore, transfer has been made on the ground that the petitioner is a resident of Jabalpur.
Residents of Jagatsinghpur.
The president, the petitioner is presently residing at Jabalpur, being a military personnel. Moreover, he is a permanent resident of Jagatsinghpur district. That apart, he apprehends danger to his life, as on one occasion his in-laws had attacked him and threatened to kill him. Notice was not issued.
No, my lord.
Considering the submissions and the grounds so raised, this court is not inclined to allow the prayer for transfer. The transfer application is disposed of. Is not inclined to allow the transfer, as the petitioner can always seek permission of the court to appear through virtual mode. And in case he apprehends any danger to his life, he can always approach the court seeking necessary orders for his protection. The transfer application is therefore disposed of, granting liberty to the petitioner to seek permission of the court below to appear through virtual mode. Stop. It shall also be open to him to seek necessary orders for his protection in case he feels threatened. He apprehends any danger to his life. So, further, the court below shall not insist upon his personal attendance unless absolutely necessary. Yes.
Item number 20.
ଆସୁନାହାନ୍ତି ସେମାନେ ସୁପ୍ରିମ କୋର୍ଟ ଯାଇଛନ୍ତି ସୁପ୍ରିମ କୋର୍ଟରେ ଯାହା ହବ ଏଠି
Letter ଆସିଛି ଗୋଟେ.
ହଁ
He is not Supreme Court to dismiss his challenge.
ଜଣା ନାହିଁ ଖାଲି ଅର୍ଡରଟା ଆସିଛି ଯେ ପେଣ୍ଡିଂ ଥିଲା ବୋଲି
None appears for the petitioner. Then Sri Hon'Ble Naik and counsel for the OPID is present. On the last occasion also, on the last two occasions also, there was no appearance from the side of the petitioner. As such, it is presumed that that the petitioner is no longer interested to pursue the IA, which is therefore dismissed for non-prosecution.
ବେଲଟା ତ ସାର୍
ବେଲ୍
ପେଣ୍ଡିଂ
ଟା dispose of ହେଇଥିଲା ପରା
ନା
ହେଇନି ତ ବେଲ୍ ଟା କରିଦିଅନ୍ତୁ. Yes.
Item 21.
My lordship, Lordship, in this matter, I am through VC, my lord.
Yes.
Lordship, in the last date of hearing him, Lordship has sought for the trial court report. My lord,
Yes.
it's in the flag P, Lordship. My lord, I am in JC since the 12th of May 22, and there is an allegation of seizure of 105 kg of ganja. There are 18 witnesses in this case, Lordship, and in this 2 year and 2 month, only 2 witnesses has been examined, and one co-accused has been on interim bail thrice by the order of this honorable court, which interim has been further increased by the honorable Supreme Court. My lordship, I don't have any type of past history.
No. We will do one thing. We will reject it you after your order from the Supreme Court. Yes.
My lord,
No. I will not grant you bail. I'm not inclined.
my lord, the co-accused has been twice released on.
You show that to the Supreme Court. You will get a bail.
No, my lord. No, my lord.
No. I will not grant you. No. I will not grant you bail, sir.
So at least interim bail, my lord.
No interim bail. We grant you interim bail, and then you get an order from the Supreme Court that the High Court should not have granted interim bail. Should have granted full bail. Regular bail.
My lord, in lordship.
What, Mr. Manohar? What are you saying?
Lordship, in lordship, humble submission, the order is there. In that case, I had not appeared in this court.
Whoever may have, it's not nothing personal here. It is nothing personal here.
In that matter, I was not appearing, Lordship.
Looking at the ground reality, this court is taking a position. Looking at the ground reality, what is happening here at the ground level?
One of the case,
Yes.
his case, your lordship has granted interim bail. ଦେଇଥିଲେ ଦିଥର ଯେହେତୁ appear କଲା his date
I have granted interim bail.
No,
Even if he is an outsider.
Full bail, my lord.
Full bail also I have granted.
Yes, ma'am.
Yes.
We'll take it
So
up.
at least,
No. The report of the court below indicates that only 2 out of 16 witnesses have been examined so
18
far.
witnesses, Lordship. 18 witnesses are charge sheeted with
2 out of 18 charge sheet witnesses have been examined so far. Yes. You produce the case diary.
Yes.
Up to date case diary be obtained. Is this matter on
22nd August.
How do you read it?
My lord,
On 5th September. Yes. Yes, sir. Item 22.
Same.
same Lordship.
Same
Both.
order.
I'm
Same
appealing
order.
for Lordship, at least interim bail.
No interim bail. Enough of
And
interim bail. I will not grant any interim bail. Either I will grant you regular bail, full bail. I may grant. I will. Let the case diary
I
come.
will undertake that. I
No.
will not approach-
No.
Since I am appearing in this matter, I
Sir,
can-
please allow me to complete. Let him obtain the case diary. If I am convinced, I will grant you full bail, regular bail. If I am not, I will reject it. That's all. Yes,
All right,
item
Lordship.
23.
May I please, your lordship, my lord, custody since 20/2024, offence alert 302/34 IPC, my
Yes.
lord, FIR laws against the 11 persons and others. My lord, informant is not eyewitnesses to occurrence. Present petitioner is not named in FIR. My lord, allegation petitioner committed murder of the deceased by assaulting dead.
Case diary ଅଛି ତ?
Case diary is there.
କଣ ଅଛି?
Case diary, my lord.
What is
Petitioner
the
not
name
named
of this
in the
petitioner?
FIR.
Kalia alias Deepak Sahu. I think earlier rejected.
ନାଇଁ my lord, ପ୍ରଥମ ଥର ଆସିଛି।
Has
What is
been
the role of
taken into
Kalia?
custody on 28/3/24.
What is the role of this
My
man?
lord, he is not named in the FIR, but final charge sheet has been filed showing him as absconder. My lord, one eyewitness, Vijay Kumar Sahu. My lord, charge sheet file 302/149 is there, my lord. 120B. And one Vijay Kumar Sahu, he is the son-in-law of the informant. He is the eyewitness, my lord.
What does he say?
He doesn't name him, my lord. My lord, I am reading. That the deceased is the Jagan, my lord. Jagan, he has gone with some of his friends to a feast, and thereafter the mother of the informant came to know that he has been assaulted. So the son-in-law has been sent to see what is there. My lord, Jagan ର ଡେରି ହେବା ଦେଖି ମୋର ଶାଶୁ ମତେ କହିଲେ ଯା ଟିକେ ଦେରଜାଙ୍ଗ ବନ୍ଧ ପଟେ ଦେଖି ଆସିବୁ। ତାଙ୍କ କଥା ଅନୁସାରେ ମୁଁ ମୋର ମୋଟର ସାଇକେଲରେ ସେଠାରୁ ଗଲି ଆଉ ଯାଇକରି ଦେଖିଲି ବନ୍ଧ ଉପରେ ଜଗନକୁ ସେଠାରେ Binay Das, Montu Sahu, Gobind Sahu, Chhabi Sahu, Kaivalya Sahu, Tarani Behera, Jitu Sahu, Jitu Biswal, Vibhuti Sahu, Silu Sahu, Pita MK Hari Sahu, Mamata ବେହେରା ଓ ଅନ୍ୟମାନେ ଯୋଜନାବଦ୍ଧ ଭାବେ ଠେଙ୍ଗା ଭୁଜାଲି ଖଣ୍ଡା ଲୁହା ରଡରେ ଅନ୍ୟାନ୍ୟ ମାରଣାସ୍ତ୍ର ଅସ୍ତ୍ରରେ ଜଗନକୁ ଅତି ନିର୍ମମ ଭାବରେ ଆଣୁଛନ୍ତି। ସେମାନେ ମତେ ଦେଖିକରି ବୋଧେ ମୁଁ ଭୟରେ ସେ ଜାଗା ଛାଡି ପଳାଇ ଆସିଲି। ସେତେବେଳକୁ ମୋର ଶାଶୁ କାହାଠାରୁ ଖବର ପାଇ ବନ୍ଧ ଆଡକୁ ଆସୁଥିଲେ। ତାଙ୍କ ପଚାରିବାରୁ ସେ କହିଲେ ଗାଁ ଲୋକଙ୍କ ଠାରୁ ଖବର ପାଇ ମୁଁ ଆସିଲି। ତାଙ୍କ ସହିତ ମୋର ସ୍ତ୍ରୀ ପ୍ରତ୍ୟାବର୍ତ୍ତୀ ବି ଆସିଥିଲା। But he is not ଅନ୍ୟମାନେ. He is not named in the.
All right. The petitioner is in custody.
But some of the witness said that soon after the occurrence, this present petitioner absconded from the village.
22-24 minute.
22-24 ଆଜ୍ଞା
22-24 minute.
Achha. The petitioner is in custody since 22/2024 in connection with such and such case. It is alleged that several persons brutally assaulted. कौन था ना deceased ना?
Jagan.
By deadly weapons causing his death.
Senapati, madam.
Causing his
Jagan
death.
Senapati.
The petitioner has not been named in the affair. Though charge sheet was submitted against him. The eyewitness
Vijay Kumar Sahu.
to the occurrence, one Vijay Kumar Sahu, who is the son-in-law of the deceased.
Son-in-law of the informant.
Son-in-law of the informant has vividly described the occurrence. He has named several assailants and the manner in which they assaulted the deceased. However, his statement is silent with regard to the petitioner. There is no acceptable evidence to prima facie show the involvement of the petitioner in the alleged offence. The petitioner appears to have been arrested on suspicion, as he had allegedly absconded from the village immediately after the occurrence. This can hardly be a ground, in the absence of other acceptable evidence to show his complicity. For all the above reasons, I'm inclined to allow the prayer for bail. Let the petitioner be released each day appearance. Sitting thumb.
Obliged.
Pardon, my lord. Monday, Tuesday also mentioned item 40 of a weekly list.
Ajay, I'll take up.
My lord.
I will take up today.
My lord. After lunch, my lord.
After lunch, no. After lunch.
Average.
And examine.
Eyewitness witness. What is this matter? Tell me.
It's a 302 matter.
302.
My lord.
Achha, so
The
several witnesses have been examined. PW 14 jaye.
14 jaye.
So.
And eyewitness guda heirante.
So what do you want?
What addendum, my lord?
Hold on. As requested by learned counsel for the petitioner, is this matter 29th August. 29th August? Learned counsel for the petitioner is directed to produce the copies of depositions of the witnesses examined before the ensuing date.
Another thing, on behalf of Mr. Devasis,
on behalf of Mr.
Devasis Tripathi, item number 3 in the weekly list, wait for the respondent.
It was the weekly list or maybe.
But,
Wait. When it will be called out, tell me. I'll have to open that system here. Wait. Yes.
I don't know, 25.
The district agent state council has requested to obtain instruction. Let's say I have grants to order dated 25/7/2024.
Correct address by tomorrow. Have you furnished the correct address?
Correct address, my lord. At that point of time, she was not staying there. That was the correct address. She has gone to his father's house. Now she has returned and we have obtained instruction.
She's suffering.
Yes. The
Then we'll allow
condition is not good.
Then we'll allow it upon.
And
The State Council has produced written instructions from the IIC, Faryad Police Station, to the effect that the petitioner is residing at
petitioner's wife.
The petitioner's wife is residing in her village and that her present health condition is not good. In view of such instructions obtained by the State Council, I am inclined to allow the prayer for interim bail. Let the petitioner be released on interim bail for a period of 2 months. क्या करेगा तो कौन?
Main application dispute.
Main application नहीं. Main application kept pending. Yes. Please the bail application. Thereafter को date करो. दिमाग पर हो.
May paper 3 months.
Huh?
May paper 3.
I know she whispered in your ears.
No.
You were initially not inclined. 2 months you were satisfied.
No, because my lord has
Mr. Pradhan, you were satisfied.
Yes,
But
okay.
she whispered in your ears.
Case of 302, the Supari killer, my lord.
Jati gauge, dheerage.
Or 7th October.
7th October. The bail application will come on 7th October. All right.
Item 26.
26, yes.
May I please, Your Lordship? Yes, under section 302-34 of IPC, read with section 25.
So the case diary.
Arms Act.
Case diary is not there. First time it has come, my lord. And your lordship earlier rejected. Your lordship observed all the things in the rejection.
Earlier rejected, yes. There's a rejection order.
11/8/22.
The time also your lordship has categorically mentioned in the rejection order that some of the witnesses has been examined, my lord. My lord, I am in custody since 8 years and 7 months, my lord. And the 8 witnesses has been till yet 8 witnesses has been examined, my lord. Out of 61 charge sheeted witnesses, my lord. And
How many have been examined?
8, my lord. I have given, my lord. And no one has whispered anything against the petitioner, even the informant, my lord. And
But because of the antecedents and because of the nature of allegations, mainly the antecedents, the petitioner has multiple criminal antecedents, including involvement in grave offences like murder.
No one will
out
whisper.
of 20 cases, my lord, already 13 cases he has been acquitted, my lord.
Mr. Samatra, you know.
My lord. They are in custody, my lord. There is no,
Expedite cause it, I'll expedite how.
my lord, this is only on personal liberty, my lord. I have filed. Your lordship will reject on the personal liberty. Your lordship has to be disposed of this matter, my lord.
I will pass a detailed order again.
No.
First of all, I'll ask you what is the change in circumstances, except for the delay.
My lord, delay is the
Delay is the only thing, except for the delay. I'm asking you what is the change in
my lord,
circumstances.
all the witnesses, my lord, those has been examined, my lord. They had not whispered
Only
anything.
8 have
against
been
the
examined. We have nearly 48 witnesses to be examined.
8 to 7 jana sab seizure witness.
No, informant is there.
Informant. Along with informant, other
Other material witnesses are there.
Yes.
But in non-bailable offences, my lord, the accused are entitled to be bailed if the court concern come to the conclusion that the prosecution has failed to establish the case, my lord. The annexure 2, your lordship, kindly have a glance, my lord.
No, I have already rejected it on merit. So why should I consider
My
the
lord,
merit
that
again?
aspect was not taken, my lord.
Which aspect was not taken?
Annexure 2, my lord. the acquittal order of other co-accused persons. Right?
Maybe.
The allegation against the petitioner is he had supplied the arms and ammunition to the assailant, my lord. And the brother of the present petitioner, the same allegation was against him, my lord. He also acquitted in that case in 2012, my lord. Lordship can have against the rejection order, acquittal order.
Yes, I've seen.
And the finding of the court, my lord, is 32, your lordship. In view of the discussion made above, I have no hesitation to conclude that prosecution has utterly failed to bring home the charges against the accused person, and therefore the accused persons are not held guilty under section 302, 120B, 109, 114, read with 34 of the Indian Penal Code, and under section 25, 27.
Anyway, you should go higher up.
My lord, dispose of these matters, I'll try.
You should go higher up against the earlier order which was passed. You should have gone. Maybe
that time
since I have already rejected, I'll pass order. But do you have the
I've cited one decision, your lordship.
Please.
Copies of the deposition is already annexed.
Annexed.
Bill application.
What decision, Mr. Samantray?
My lord, it is Javed Ghulam Nabi Sheikh versus State of Maharashtra, my lord, on personal liberty, my lord. This bail application has to be disposed of on personal liberty, my lord. Not improvised gravity drafted discretion, my lord.
Hearing concluded or reserved?
Obliged.
Item 27.
Yes, sir.
Item 28.
Research the total.
28, my lord. Here, charge sheet has been filed against the present petitioner and other accused person for offense under section 307, 323, 324, 294, 341, 506, 326, and 34 of the IPC.
Earlier files.
Yes.
Earlier filed. There was the order first or second.
First or second, my lord. In the meantime, charge sheet filed, and other co-accused person are already released on bail.
So you file a petition for modification. I'll say that you will maintain parity.
In this case, my
No.
parity order.
No.
First or second.
No. You have not complied with the order of this court. So you may seek a modification of that order. I will grant you that liberty. I'll say that the court will maintain parity. But how can this order be passed
Because charge sheet has been filed, so that's
So there will be two orders.
yes.
No. You file the petition for modification, not press this main application. In that case, I will pass that order.
Yes, my lord. Then I will.
Leave this matter next week as prayed for.
I will not press this matter. Then I will file a modification in that case.
Sir, you first file a non-modification petition,
Yes, my lord.
and then this matter can be not pressed.
Yes,
Item 29.
307 and other allied offences, my lord.
Anybody has been granted bail?
My lord, one person has granted bail subject to injury.
Injury, my lord.
If it is found to be simple, but they are named in the affair. This present petitioner is not named in the affair.
Named in the affair, my lord.
Were named.
Same order kar do.
And all.
Same order. Yes.
Item 30.
Item 30.
Modification.
Item 30, may I please you? I have filed the modification, my lordship. Regarding the correction of the petitioner name, my lordship. As SK Nijam alias SK Nijamuddin instead of SK Ninam alias SK Nijamuddin in the page number 8.
You mention it in your your bail application.
Bail application, yes.
Achha. So this is a mistake of the court.
My lordship.
In the order dated 25/7/2024.
Another mistake, my lordship.
Again, sorry. The name of the petitioner be mentioned as SK Nijam alias Sheikh Nizamuddin. Bail application. Yes, another.
Another, my lordship, opposite party represented by that state council name has not.
Further, the name of the state council appearing on that day be reflected in the cause list in the order sheet. Who was appearing on that day? On 25/7. I think you were appearing.
25/7. Yes.
The name of Sashikanta Mishra. Sashikanta Mishra, AC be reflected in the order sheet.
Nice.
Anything
Nice.
else?
Aଜ୍ଞା
Anything?
ନାଇଁ ନାଇଁ ଆଉ ସବୁ ଠିକ ଅଛି
Nice. Like the password. Like
Password
the
item number
Hon'Ble.
18.
Please, your lordships. On application for transfer of fancy case from JMC Nimapada to JMC Bhubaneswar, my lords.
Any settlement?
Let's
Any chance of settlement? Yes, Mr. Ras.
let me see.
That's to some of the photocopy of the certificate of the order sheet of the court of the law in the JMFC Nimapada, and it is a case under section and no the NI Act. And
Let it go for mediation. Let them decide, my lords. We will settle.
Yes, what you say?
no, accused.
You are the complainant. This is a 138 matter. You are the complainant.
No, I am the complainant.
Oh, you are the complainant. He is the accused. So if you can sit and sit across the table and decide the matter, end of the entire dispute. These are matters best decided through mediation. If you say, I'll refer it to mediation.
I have not taken instruction.
Take instruction. Let's this matter next week.
And that, my lord, it is page 23. We will have a glance to the.
What is your submission? Tell me, then I'll see.
That is once accused statement is over.
Oh, accused statement is over.
Accused statement is over. Then
Argument?
Argument. It is for argument.
Each stage कौन होगा?
Let them one chance to be given.
What chance?
If it gets settlement.
No. At this stage, there will be no transfer. हेला आपण पहिले तर मग accept करले सब देखिया पे समय पे
526
Okay, at this stage of argument, why will it be transferred?
Argument.
Yes. The petitioner is the accused in 1CC case number 166 of 2018 of the Court of Learned JMFC Nimapada. Stop. He seeks transfer of the said case to the Court of Learned JMFC Bhubaneswar. In course of hearing, it is brought to the notice of this court by learned counsel appearing for the opposite party, complainant opposite party, that the trial of the case has almost concluded, with the case being posted for hearing arguments. So, having regard to the above facts, this court does not deem it, does not find any justified reason to transfer the case at this stage of the trial. The transfer application is therefore dismissed. Yes.
So item number 27.
Weekly list of supplementary भूले मार दें. $27, yes. None appears next week. ତାପରେ ସଲା ସେତିକି ଦିଟା ଥିଲା ଆଉ ଗୋଟେ ଥିଲା ବୋଧେ ଅଲ୍ ୱିକଲି ତିନିଟା ଆରମ୍ଭ
Lords, I met pardon, Lords. Item 26 in the weekly list kindly just pass over. What pass?
26?
Yes.
All right, pass. Not one pass over, it will be passed over after completing everything. I'll take.
Yes, I'll open.
Yes.
20 supplementary.
Weekly.
Yes.
Weekly तो reach करने की बस क्यों? 12th August को जाइए.
At then.
Weekly list item number 3.
None of them. None of them study.
ये none of it आगुरी जाइए आगुरी जाइए. Yes. Item 3.
Item 3, on behalf of Mr. Devashish Tripathi, whereas for the respondent, appellant has Mr. Senior Advocate Mr. Praful Rath has completed the pleading and we are related to give a reply. As Mr. Tripathi is ill today, matter can be taken on Monday.
ପଛରେ ଲାଗି ପାତିକିରି ଆଜ୍ଞା ଆମକୁ ଜବରଦସ୍ତି ଆର୍ଗୁମେଣ୍ଟ କରାଇଲେ.
He is making a
lighter than that. Not serious.
Yeah, but she's saying it in all seriousness, so I thought it must be very, very serious.
Right.
We'll take it up next week.
Well.
All right. Therefore, adjournment is made on behalf of Sri Devashish Tripathi,
proposal भी देई
learned counsel for the respondent on the ground of his personal illness. This is this matter next week. Yes, Mr.
ଗୋଟେ proposal ଦେଇଛି ଆମର ଆମ କେସ୍ ହଉଛି 1500 ସ୍କୋୟାର ଫୁଟ ଆମେ ବାଡି ବସିକି ରହିଛୁ ଯାହା ବି ହେଇଛୁ ସେ କହୁଛନ୍ତି ଯେ ଆମେ ରେଣ୍ଟ ଥିଲୁ
Oh, that melody.
ସେଇ ମେଲାଡି ମୁଁ ଆମ ଲୋକର ଘର ମୁଁ ଦେଖୁଥିଲି ଗୋଟେ ଝାଟି ମାଟିର ଘରଟେ 300 କି 400 ସ୍କୋୟାର
The mediation book, mediation book.
ସେ ରାଜି ହେବେ ଯିବା ତ ନହେଲେ ନାହିଁ କାହିଁକି
In the meantime, you ask Mr. Tripathi. To agree, nothing. Proper to
right of center
If you want, we can settle it. Yes.
Item number 5.
Number 5. What is this matter? Either LCR আসছে না নেই?
LCR আসছে।
Scan. Sir, you said that LCR is necessary to be produced.
Yes.
What is this matter, sir?
Matter means it will be better if I place the list of dates before or receipt before.
Yes.
My list of dates are available in the record. Date chart.
Yes.
The suit property which belonged to the government of Orissa was allotted to one Fakir Charan Mahanti by way of lease granted by the state government.
Sir.
The plaintiff respondent number 1, namely Sri Prabir Kumar Das, obtained the suit property through tripartite registered conveyance lease cum sale deed bearing number 7136 dated 26/8/81 executed by Fakir Charan Mahanti with the consent of GA Department, Government of Orissa, in favor of respondent number 1, Prabir Kumar Das. The plaintiff respondent, namely Prabir Kumar Das, executed a registered agreement for sale on 4/12/2017 with respect to the suit scheduled property in favor of Messrs. Cottage Design Private Limited for a consideration of 12.60 crores and received a sum of rupees 1 lakh from Messrs. Cottage Design Private Limited as advance. On 25/5/20, plaintiff respondent Prabir Kumar Das, without disclosing about the agreement with Messrs. Cottage Design Private Limited, received payment of rupees 40 lakhs with respect to the suit scheduled property from the defendant appellant firm. On 1/6/2020, the above agreement for sale executed in favor of Cottage Design Private Limited was cancelled by plaintiff respondent number 1, Prabir Kumar Das. Till 23/7/2020, this suit property was leasehold property. On 24/7/2020, the plaintiff respondent number 1, Prabir Kumar Das, deposited an amount of rupees 3,09,91,736 with GA Department for conversion of the suit property from leasehold to freehold. During the period 25/5/20 to 37/2020, defendant appellant partnership firm paid and plaintiff respondent 1, Prabir Kumar Das, acknowledged the receipt of a sum of rupees 2.80 crore only from defendant appellant firm with mutual understanding between the parties that the defendant appellant firm shall develop and construct multi-storied residential building apartment over the suit property on flat sharing basis between the parties. 7/8/2020. This is the first agreement, development agreement.
Sir.
Development agreement executed between the plaintiff respondent number 1, Prabir Kumar Das, and the defendant appellant partnership firm, which was notarized before the notary public, Subhash Chandra Mahapatra, that is Exhibit A. In this, there was an agreement that basement plus steel plus 6th floor will be constructed, and 50% of the built-up area up to 4th floor will be allotted in favor of the plaintiff, who is the landowner. Now, on the next subsequent date, on 8/8/2020, subsequently on the very next day of execution of development agreement dated 7/8/2020, on 8/8/2020, an agreement in the name and style of supplementary deed of agreement for allocation of share between developer and the landowner was executed between plaintiff respondent number 1 landowner Sri Pravir Kumar Das and defendant appellant partnership firm represented by Vibhuti Bhushan Patra, which was also notarized before Notary Public Sri Subhash Chandra Mahapatra on 8/8/2020. According to this subsequent agreement, it was agreed that the defendant appellant will pay to the plaintiff respondent 15 crore 15 lakhs in no sharing in the construction. Now, on 8/8/2020, the appellant partnership firm deposited a sum of rupees 63 lakhs 949.85 paisa with Bhubaneswar Municipal Corporation BMC as per details in the demand notice of BMC for the building permit application with reference to ANB 200401. 28/2020, the conveyance deed for conversion of GF department leasehold land to freehold in Bhubaneswar Municipal Corporation limits with respect to the suit property was executed between the Governor of Odisha represented through the Director of Estates and ex officio Additional Secretary to Government GA and PG Department and plaintiff respondent number 1 Sri Pravir Kumar Das. On 3/9/2020, the conveyance deed dated 28/2020, Exhibit 1, was registered on 3/9/2020 in the office of the Sub-Registrar District Sub-Registrar Khurda, Bhubaneswar, to the suit property. Pravir Kumar Das, in between, had received 5 numbers of security checks from the defendant appellant partnership firm with the condition that the plaintiff respondent number 1 will return the checks to the appellant on receipt of the balance amount of rupees 12.35 crores, because he is to get 15 crore 15 lakhs. Out of that, 3.20 lakhs has already been 2.80 plus 40. ପରେ ବି ଦିଆହେଇଛି 320 adjust ହେଇଗଲା ପରେ ଆଉ ବାକି 1235 ଦେଇଦେଲେ he will return these checks. On 14/12/2020, on 7/11/2020, the plaintiff respondent number 1 encashed check number 47013 dated 20/10/2020 amounting to rupees 20 lakhs. On 4/12/2020, the plaintiff respondent number 1 encashed check number 047014 dated 30/10/2020 amounting to rupees 20 lakhs. On 14/12/2020, managing partner of defendant appellant partnership firm, namely Sri Vibhuti Bhushan Patra, expired. So till this, it was somehow the matter was pulling on well. Shortly after, on 5/1/2021, the reconstitution of the defendant appellant partnership firm, namely Messrs. Creative Builders and Consultants, is made on 5/1/2021, incorporating the legal heirs of late Vibhuti Bhushan Patra, namely his wife, Srimati Nirupama Patra, as its managing partner, his daughter Rajalakshmi Patra as partner, and his son Rajat Kumar Patra as partner. On 13/1/2021, Bhubaneswar Municipal Corporation filed its letter number 2217 dated 31/1/2021 intimated the defendant appellant partnership firm about the decision of the second DP and BP committee meeting of Bhubaneswar BMC regarding approval for construction of the proposed B plus S plus 6-story MIG residential apartment building over the suit property subject to compliance of 6 numbers of parameters mentioned in the said letter. On 2/2/21, the defendant appellate firm applied to the executive engineer public. This was one of the conditions. Firm applied to the executive engineer public health division Bhubaneswar for grant of NOC for water supply and sewerage connection to the proposed project over the suit land. On 23/2/2021, the defendant appellant firm applied to the Odisha Fire Service for grant of its fire safety recommendation with respect to the proposed project over the suit land. On 25/2/2021, Odisha Fire Service granted fire safety recommendation with respect to the proposed project over the suit land. On 14/4/2021, the defendant appellant had by its letter number 70 dated 14/4/2021 submitted the structural drawings and designs of the proposed project over the suit land to the Department of Civil Engineering Veer Surendra Sai University of Technology Burla for vetting and approval. That is Exhibit 10. On 24/21, the Registrar of Farms Odisha acknowledged the deed of reconstitution of defendant appellant partnership firm. On 30/4/2021, the defendant appellant firm deposited bill amount of rupees 1,06,200 through NEFT at the HOD Civil Office of Veer Surendra Sai University Technology Burla. That is Exhibit 10. On 4/5/21, the Executive Engineer Public Health Division Bhubaneswar granted NOC in favor of the defendant appellate firm with respect to the proposed project over the suit land. On 17/6/2021, the Department of Civil Engineering Veer Surendra Sai University of Technology Burla by its letter number 17/6/21 vetted the structural designs and drawings and designs of the proposed project over the suit land. On 21/7/2021, Srimati Nirupama Patra, the new managing partner of the defendant appellant firm, by its letter number 124 dated 21/7/2021, intimated to the plaintiff respondent number 1, namely Sri Prabir Kumar Das, bringing to his notice about the development agreement dated 7/8/2020, supplementary agreement dated 8/8/2020, and general power of attorney dated 3/9/2020. On 9/8/2021, the plaintiff respondent number 1, Sri Prabir Kumar Das, sent his reply to letter number 124 dated 21/7/2021 of the defendant appellant partnership firm. In response to the letter dated 9/8/2021 of the plaintiff respondent number 1, the defendant appellant partnership firm sent its letter number 141 dated 17/8/2021. On 25/8/2021, the defendant appellant firm deposited rupees 64,72,509 with BMC to acquire permission for the proposed project over the land in question. 25/11/21, Bhubaneswar Municipal Corporation by its letter number ANB 2008 dated 25/8/2021 granted permission under subsection 3 of section 16 of the Odisha Development Authorities Act 1982 for construction of B plus S plus 6-story residential apartment building over the land in question. On 1/9 from 15/4/21 to 1/9/21, the second wave of the COVID pandemic situation was in peak. If at all there was any stalemate, it was only for this COVID period of 5 months. Otherwise, there is no delay on part of the defendant appellant. And there was a lockdown, shutdown of the entire state of the state government. Office were running with skeletal staff with prohibition to public to enter into the premises. On 14/9, this is a material that your lordship may kindly take note of it. On 14/9/2021, plaintiff respondent number 1, without being personally present, without signing and verifying and affirming the plaintiff pleadings, filed CS number 1941/2021 of as plaintiff against the defendant appellant partnership firm in the court of the Civil Judge Senior Division LR, Bhubaneswar, through its authorized representative Sri Akshay Kumar Parija, who has verified the plaint and sworn the affidavit. And this is one of our grievance. On 14/9, along with the plaintiff Prabir Kumar Das, through his authorized representative Akshay Kumar Parija, filed petition under 39 Rule 1 and 2, read with section 151 CPC, which has been registered as IA number 1 of 2021 to pass temporary injunction against the opposite parties appellant firm, restraining them and their men, agents, followers, masons, laborers, assignees, or anybody claiming through them from in any way changing the nature and character of the suit scheduled land and make any type of deal with anybody in respect of the suit scheduled property pending disposal of the suit. The permission letter of Bhubaneswar Municipal Corporation, by its letter number ANB 2008, dated 25/8/21, was digitally signed by the city planner BMC on 16/9/2021. What I beg to contend that till the approval is not signed or communicated, no builder can proceed with the construction. So even after the institution of the suit, this was communicated. So on the date of the filing of the suit on 14/9, there was no fault on part of the defendant appellant to proceed with construction or complete payment. Two things are there. That is also, so far as the completion of construction is concerned, that is 36 months plus 6 months, 42 months. And so far as the completion of payment to the plaintiff respondent is concerned, that is 30 months plus 6 months. 24 months plus 6 months, 30 months. That was not also over. The Learned Civil Judge Senior Division Bhubaneswar admitted the civil suit fixing date of appearance of the defendant appellant herein to 7/12/21. The Learned Civil Judge, while fixing the date of appearance of the defendant appellant, passed following order. Both the parties are hereby directed to maintain status quo as on date over the suit scheduled property till 4/10/21. 7/10/21, the defendant appellant firm applied to ORERA for registration approval of proposed project over the suit land by online project application number ORERA 10211-20478, dated 7/10/21, which has been registered by ORERA as file number RP/699/2021, MSL number 988. On 11/10/21, the defendant firm appellant herein filed its objection to IA number 1 of 2021 arising out of CS number 1941/2021 filed by the plaintiff respondent number 1. The plaintiff respondent number 1 through its representative Akshay Kumar Parija filed the status quo order passed by the learned civil judge senior division Bhubaneswar before the ORERA authority. 22/10/2021. Defendant appellant firm filed its letter number 185 dated 22/10/81 submitted an application to ORERA. 22/10/2021. The ORERA authorities rejected the registration approval of the proposed project over the suit land on account of status quo order, which was filed by his representative before the ORERA authority.
Yes.
Since there is a status quo order by the court, that my application was refused to be registered. 10/11/2021, defendant firm appellant herein filed its written statement. Then plaintiff respondent filed an application under Order 6 Rule 17, just to formal. I was not aware that 320 has been received, that was allowed. The defendant appellant firm filed its objection to the said amendment application. The learned civil judge senior division Bhubaneswar allowed the application of the plaintiff respondent number 1 to amend the plaint with respect to payment of rupees 3 crore 20 lakhs instead of 2.80 lakhs, but disallowed the amend the date of cause of action and imposed rupees 500 cost on the plaintiff. 7/12/2021. Plaintiff respondent number 1, Sri Prabir Kumar Das, through his authorized representative, filed the consolidated plaint. 19/2/2022. Defendant appellant firm filed its additional written statement in CS number 1941 of 2021. 19/2/2022. Defendant appellant firm filed its additional objection to IA number 1 of 2021 arising out of CS number 1941 of 2021. 12/4/2022, the defendant appellant firm as petitioner filed IA number 2 of 2022 arising out of 1941 of 21 and IA number so and so under Order 39 Rule 2A, contending inter alia that the plaintiff with an ulterior motive, knowing fully well the order of status quo is in force in respect of the suit scheduled property, violating the same by putting a hoarding in respect of the suit scheduled property and misguiding the prospective purchasers contacted to the petitioner for their proposed booking after clearance of RERA and defaming the petitioner with prayer to punish the plaintiff and attach his properties, so also put him in civil prison for violation of the order of status quo. On 7/5/2022, on the basis of the pleadings, the parties, the learned civil judge senior division Bhubaneswar framed as many as 8 issues. On 16/5/2022, the learned civil judge Bhubaneswar, after hearing the parties in IA number 1 of 20 arising out of CS number 1941 of 21, made the status quo order absolute and directed both the parties to appear in the mediation center. Then, in view of the order passed in IA number 1 of 2021, Learned Trial Court directed to send the case record to the district mediation center for settlement of dispute between the parties. On 16/9/2021, it will appear from the order of the Learned Trial Court that the mediation failed. On 27/9/2022, the plaintiff respondent number 1.
These facts may not be very relevant because these are all examine
skip on 4 the authorized, then item number 59. Akshay Kumar, Prabir Kumar Das was examined as PW1. Akshay Kumar Parija was examined as PW2. The plaintiff filed a petition for deposit of an amount of rupees 3 crore 20 lakhs. On 15/12/2022, during evidence of PW2, one document has been marked as exhibit. Evidence from the side of the plaintiff is closed. On behalf of the defendant appellant, a petition was filed to expunge exhibit 10 from the evidence since it is fraudulently manipulated document. On this petition was heard, Learned Trial Court rejected the said application, then Srimati 21/3/23 Nirupama Patra, managing partner, was examined as filed his affidavit on 21/3/23 as DW1. The examination commenced, documents were marked, cross-examined by plaintiff in part. On 9/5/23 to 26/6/23, further cross-examination by the plaintiff. Evidence from the side of the defendant was closed. Learned advocate for the parties concluded their arguments in CS number so and so.
I think that's all right. Skip it.
Then pronounced to the judgment on 23/8/23. Suit was allowed. Decree is prepared. Neither the defendant has handed over the delivery of possession. This was the ordering portion of the trial court judgment. Neither the defendant has handed over the delivery of possession of the suit property to the plaintiff, nor the plaintiff has taken over the possession, nor the plaintiff has taken resort to law for taking over the possession of the suit property pursuant to the direction of the Learned Trial Court. On 12/9/2023, the plaintiff, without taking over possession of the suit property, remitted a sum of rupees 4,49,40,274, that is 3 crore 20 lakh towards principal and 1.29.40,274 towards interest to the bank account of defendant firm through RTGS. On 12/9/2023, on the same day of remittance of the above amount to the bank account of the defendant firm through RTGS, without taking over the possession of the suit property from the defendant before expiry of appeal period of 30 days, the plaintiff executed a registered sale deed in favor of Messrs. SJ Environmental Solutions Private Limited and Messrs. MGM Estate and Properties Private Limited for total consideration of 12 crores. Till this point, it was a litigation between the defendant, appellant, and the plaintiff, Prabir Kumar Das. From this onward, this new purchaser intervened. The defendant firm filed criminal miscase number so and so in the court of the Executive Magistrate cum Additional DCP Bhubaneswar under Section 144(2) CRPC against the plaintiff's authorized representative, namely Akshay Kumar Parija, praying therein to pass an urgent order under Section 142 CRPC directing IIC Sahidnagar Police Station to strictly implement the order of the Honorable Civil Judge Senior Division LR passed in CS number 1941 of 2021, dated 23/8/23 with respect to the suit property. Learned Executive Magistrate cum Additional DCP Bhubaneswar in criminal miscase number so and so passed order restraining both parties members from changing the nature and character of the suit scheduled land and from creating any sort of disturbance therein till the next date, fixing the next date to 22 923. The defendant firm as appellant filed RFA number 85 of 2023, saying therein to set aside the judgment dated 23/8/23 passed in CS number so and so by the learned Civil Judge Senior Division LR and LTB Bhubaneswar. Along with the memorandum of appeal, the defendant appellant firm as petitioner filed an interim application under order 39 rule 1 and 2 read with 151 CPC praying therein to
Sir, is it relevant? Hoga purata detail ta padhiba? Is it necessary to go to the detail?
No, skip kar do. Last say 80 serial number 80 that together. On 22/9/2023, Learned First Appellate Court passed status order with respect to the suit schedule property. Now, the appellant defendant firm filed two separate applications. One for addition of parties, and the other is under section 151 CPC for permission to return the money transferred by plaintiff respondent number 1 to the account of defendant appellant. Both the applications were allowed. Now, on 16/10/2023, advocate for the plaintiff respondent filed objection to the petition dated 9/10/2023 by the defendant appellant to refund back 4 crore 49 lakhs to the account of plaintiff respondent. On 16/10, the First Appellate Court impeded respondent purchasers and allowed the defendant appellant to refund back 4 crore 49 lakhs. Accordingly, if your lordship skips over little later, on 2/11/2023, the advocate for the appellant filed a memo along with the copy of the NEFT transaction and submitted that the order of 16/10/2023 has been complied with. On 8/11/23, in CMC number, this is not material.
So this amount was refunded?
Amount was refunded again to him. The RFA number, the advocate Bhaskar Panda associate filed Vokalatnama. Then your lordship may skip over. Learned. Your lordship may kindly come 94.
Yes.
11/12/23. Advocate for appellant filed a petition under order 41 rule 27 CPC for acceptance of additional evidence, giving a list thereof of 14 numbers of documents. Advocate for the appellant filed the consolidated amended appeal memo in RFA number 85 of 2023. The learned First Appellate Court rejected the petition dated 29/11/23 filed for amendment of WS being devoid of merit. In respect of the petition dated 11/12/23 filed by the appellant under order 41 rule 27 for adducing additional evidence, the learned First Appellate Court directed that the said application is to be disposed of at the time of final hearing. But this has not been heard nor dealt with in the final hearing of the case. Now, on 29/2/24, the First Appellate Court pronounced the judgment, confirming the judgment of the order, trial court, and hence this regular second appeal. Now I invite your lordship's kind attention. I have formulated the grounds of appeal, substantial questions of law. Your lordship may kindly come to page 174. The learned trial court has disposed of it issue-wise. the learned first appellate court has also discussed it issue-wise. And I have also formulated the substantial questions of law issue-wise. Now, 174 mechanics.
Yes.
For that, in view of the respective pleadings of the parties, the learned trial court framed as many as 8 issues. Issue number 1, as framed by the learned trial court, is to the effect whether the suit is maintainable. The maintainability of the suit was challenged by the defendant appellant on the ground of improper presentation, which has been dealt with by the learned trial court under paragraph
Sir,
19.
without going through the detail, you may only say how it was dealt with by the trial court and how it was answered by the first appellate court.
Minor.
So we need not go through the entire.
No, just I am pressing that.
Yes.
I am just pressing that. Issue number 1 was answered against the defendant by the trial court, confirmed by the first appellate court.
On the ground that it was improperly presented. All right. So that was your contention,
Yes.
it was not accepted.
Yes, it was not accepted. The ground of my contention was on the date of the presentation of the plaintiff, on the date of the presentation of the plaintiff, there was no proper authorization letter.
Akshay Kumar Patra.
Akshay Kumar Parija.
Akshay Kumar Parija, sorry.
Parija. Then.
But what was the finding of the trial court in that in this regard?
He said, "Khali one line, it is correctly filed." The finding I am coming to that. At page 42 of its judgment, the trial court held that non-availability of authorization letter in favor of PW2 who presented the suit at the time of filing of the suit cannot be fatal to this.
So that was confirmed in appeal.
That was confirmed in appeal. A first appellate court judgment that has been dealt with at page 279 of the.
So finding is the same.
I am confirmed. I am just quoted it.
Yes.
I am just it. The above finding of the learned trial court was challenged in RFA number 85/23, which has been dealt with by the learned first appellate court under paragraph 11 of its judgment, available at its internal page 29 and 30, and the learned first appellate court held that the authorization letter dated 12/9/2021 and the notarized on 15/9/2021 at USA does not affect the plaintiff from improper presentation of the plaintiff, as the same has been subsequently ratified by the plaintiff, and accordingly the contention of the appellant merits no consideration. According to me, there is no subsequent ratification by the plaintiff.
It's a factual finding. So if he finds that from the evidence, if it is a perverse finding, that's a different matter.
It's absolutely a perverse finding,
All.
according to my submission. Now,
second is this cause of action. This cause of action appears to be something which you may say. This cause of action.
no, presentation is also equally bad.
That point is taken.
Yes.
That point is taken.
Then,
Then that's a cause of action now.
next asila cause of action. Issue number 2. Before I part with issue number 1, kindly I beg to place 2 provisions of CPC.
Yes.
Order 26, Section 26, Order 4, Rule 1, Order 6, Rule 14.
Section 26, order?
Order 6, Rule 14.
Rule 14.
Order 4, Rule 1.
Yes.
Then Order 6, Rule 14.
Yes.
And Rule 15.
Yes.
Now, then order for Rule 1. Every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoint in this behalf. Then every plaint shall comply with the rules contained in orders 6 and 7 so far as they are applicable. The plaint shall not be deemed to be duly instituted unless it complies with the requirements specified in sub-rule 1 and 2. So it is the bounden duty of the trial court to see that whether the suit has been properly instituted and presented and not. Plaint has been presented or not. Then Order 6, Rule 14. Pleading to be signed, every pleading shall be signed by the party and his pleader, if any. Provided that where a party pleading is by reason of absence or for other good cause unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or to sue or defend on his behalf. Here, plaintiff has not filed because of his absence at USA. He says that I authorized my representative Akshay Kumar Parija to sign, verify and to institute this suit. But there is no authorization to sign, verify and affirm.
Yes.
The authorization, there are two authorization letters. One available with the plaint itself, and subsequently one was produced and approved by Akshay Kumar Parija, that is Exhibit 10.
The original one.
The original one. The document available along with the plaint is not an original document. It is a photocopy. If your lordship looks to that, that is available in the trial court. LCR.
Look at the plate.
Fine. Along with the plate, it has been faxed. There are, at the end, there are two documents. First page, to whomsoever it may concern. Your lordship got first one? Prabir Kumar Das has signed it. To whomsoever it concerns.
Trial court to eta deina. Ochi, support it. Page 88. Shoot for declaration gala. ये प्लेट तो लास्ट है कुछ
last page there. Authorization tab. May I read place that document?
Sir, let me just find out. Last page is the verification and affidavit. Nahi. Second copy रे भी नहीं तो तक बाहर कर दी चिंती एनी अपन प्लेस करूँ थिबो नहीं they have referred to the authorization letter in the list of documents. Oh yes that I'm the authorized representative of the plaintiff. Yes
সেই কপিটা দেখলে না
no I'm sorry that
সেই
is not.
কপিটা দিকে বাহির করো এটা ফিজিক্যালি ଆପଣ ନ ଦେଖିଲେ
नहीं सेटा थिबो जे सेटा एथरे the document
it will not be possible or appropriate to appreciate my submission.
somehow it is not there. Thibo se पछरे फोटो खिची दिथियो
ଆମେ ସାର୍ଟିଫାଇଡ୍ କପି ପ୍ରିଣ୍ଟ ଯେତେବେଳେ ଆଣିଥିଲୁ ସେଇଟା ବି ଆମ ପାଖରେ ଅଛି
नहीं can you if you pass it on to save time I think you have a copy.
नहीं another copy is not there.
नहीं दो देखे मैं सारे देखी देखी दे दियो
तार तळटा होची exhibit 10
से जो माने प्रिपेयर करछंती से माने they do not know whomsoever is concerned. आई प्रवीर कुमार दास हां
ସେଟା ଟିକେ ପୁରା ଦେଖ ପଢି ଦିଅ
hereby authorized Mr. Akshay Kumar Parija agent about to initiate civil suit before civil judge Senior Division Bhubaneswar against creative builders representative. Well, authorization is to initiate a civil suit.
there is no authorization to sign verify or affirm on oath.
Will it not be included in that?
Miller?
Civil suit is to be filed.
There is no evidence to that effect.
That's a different matter. But I'm just saying, will merely because it does not say that you have to sign or as per the.
Then kindly exhibit 10 टा लिख देखते हो.
Exhibit 10.
आगे.
The staff who were working, the staff of the civil court who were working when you were young and we were practicing, and the persons who are working now, there is a huge difference.
Obvious.
कि खोजी के बाहर करिबा से how a LCR is to be prepared, there are set rules in the GRC also.
Yes.
That is never followed. Yes, Mr. Bag, you will also agree with it. We are having a tough time, and particularly when these matters are being digitized, it is very, very difficult to find out. मिलियो नहीं मिलियो एग्जिबिट टा मिलियो एग्जिबिट एविडेंस परे रहइबा कथा सेटा को रखी एग्जिबिट 10 सर
हां एग्जिबिट 10 रो फर्स्ट पर्सन टा जहां लेटर टाइप है जी सेटा समान अछि
आगे एग्जिबिट 10 टा कोन
that authorization letter जोटा देखिले आपको देखिलु
सेटा रो authorization
letter एटा notarized नो एटा notarized
okay
तो notarized ता तळे
I think we will do one thing. It exhibit 5 wala. Exhibit 5. Exhibit 7. Exhibit 8. 9. With objection mark. Yes, exhibit 10.
This has been filed on 15/12. 2022.
Yes.
During the evidence of PW2.
Yes.
What I beg to.
The same thing. The same document.
Same thing. खाली ता तळटा देखंतु
personally appeared before me. Yes.
It's notarized.
It is notarized.
On 9/15/2021. 15/9/2021 में पढ़ाई
ये अमेरिका रे हो सेट में 9/15 लिखा है माने
15/9/2021.
Yes.
one day after.
One day this was notarized one day after the presentation of the suit.
And filed on 22.
And filed on 15 ସେଠୁ ଆସିଲା
ନା 15 ପଇସା ଟିକେ
filed in court as exhibit 10 by PW2, if your lordship looks to the list of document exhibits
Yes.
on 15/12/2022. Right hand column top.
Yes.
So what I beg to impress upon your lordship is that on the date of the presentation of the suit was admittedly filed on 14/9/2022. This was not presented till 15/9/2022. But it was physically filed in court on 15/12/2022.
Yes.
Kindly mark the difference. And absolutely there is no, by that time, already the evidence of Prabir Kumar Das was over. There is no application for its ratification. Then, your lordship may ask me a further question. Whether a authorized person can maintain a suit or not. Yes. 15 term पढ़ी थी. Order 6 rule 15.
Yes.
Press code. Save as otherwise provided by any law for the time being in force, every pleading shall be verified at the foot by the party or by one of the parties pleading or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case. This is the qualification. He must be the person verifying this Akshay Kumar Parija has signed, verified and affirmed oath. But what is his qualification? He must be acquainted with the facts of the case. Then 2 is the person verifying shall specifically by reference to the number of paragraphs of the pleading, what he verifies of his own knowledge. What I beg to impress upon your lordship is that the verification must be very specific. It cannot be evasive. What he verifies of his own knowledge and what he verifies upon information received and believed to be true. The verification shall be signed by the person making it and shall state the date on which the place at which he has signed. The person verifying the pleading shall also furnish an affidavit in support of his pleading. This is the amended requirement.
Yes.
Previously, this affidavit part was not there. It was only a simple verification. Now, I invite your lordship's kind attention to the plaint in question, that is CS number 1941 of 21 has been presented by one Akshay Kumar Parija, claiming himself to the authorized representative of the plaintiff, Prabir Das. Along with the plaint, photocopy of an authorization letter of plaintiff Prabir Kumar Das dated 12/9/2021 has been filed in favor of Akshay Kumar Parija, PW2. The alleged authorization letter dated 12/9/2021. Duty is heavy and responsibility is sharp on me to prove both the documents that they don't qualify Akshay Kumar Parija to present the plaint. Because I am at the very root of the matter. The representation is that the alleged authorization letter dated 12/9/21 available with the plaintiff does not contain the signature of Akshay Kumar Parija. It is a basic requirement. If I authorize somebody, suppose a power of attorney is granted in favor of a person in favor of another person,
Yes.
his signature remains in the power of attorney or the authorization letter or the vice versa. Then it is not written on stamp paper. It is a scrap of single plain paper. The said authorization is not notarized by the notary public at USA. I am speaking of 12/9. 14/9 this suit was filed. 12/9 this was available with the plaintiff. This has not been notarized at US by the Consul General or Additional Consul General. Then this said authorization does not contain the approval of the Consul or Additional Consul of Indian Embassy at USA. Your Lordship may ask, under what law or under what notification this is you are insisting upon such requirement? Very good. This is one page, so I would like to place it because it is an important document.
Yes.
লোগোটা আছে ইন্ডিয়ান এম্বাসির অশোক স্তম্ভ লেফট হ্যান্ড কলাম টপ Embassy of India continues to provide miscellaneous consular services through postal, mail, shipping, download the miscellaneous application form and fill it up carefully. Each applicant is required to fill up a separate form and affix their photograph. The applicant's requirement either on plain paper or Indian stamp paper embassy does not. No, the embassy does not prescribe any specific format for power of attorney affidavits and could be as applicant's requirements either on plain paper or Indian stamp paper. Embassy does not provide stamp papers. All applicants who are Indian nationals must ensure that their signatures on power of attorney or affidavit matches with the signature in the current valid passport. In case signature differs, the documents would be sent back to be signed again as in the passport. After the applicant sign power of attorney and affix one current passport size photograph on the last page of the power of attorney, the power of attorney needs to be signed and witnessed by two individuals other than immediate family members with their full names and addresses.
Sir, I may pause you, ask you to kindly pause for a moment because I am aware of this provision. This is known as apostilling. This is known as apostille.
Miller.
Apostille. So the Indian government also does it. Here, the Home Department does it.
Miller.
For a person, for Indian national who wants to create a document and go, and vice versa, that is there. But the problem is that the point that I would like to know, I would request you to address this court, so whether non-ratification by the Consul General is fatal, can be fatal to the plaintiff.
Notification is there?
Where is that notification? That it has not been done. The exhibit 10 is visible, I am seeing it. It has not been done by the Consul General. Whether that can be treated as fatal to the
suit. ତଳକୁ ଟିକେ ଦେଖନ୍ତୁ fee for power of attorney.
ଆଜ୍ଞା $20 ଇତେ ଦିଶେ
ଏଇଟା ଦବ ଏଥର କିଛି ଦିଆ ହେଇଛି ବୋଲି କି ତାର ନାହିଁ
ନା ନା ସେଇଟା ନ ହେଇଥିବା ଯୋଗୁ ନୋଟାରାଇଜ ହେଇଛି but whether say notary ଟା they again ratify ହେବା ଦରକାର consul general which happens in many of our cases also I have seen but that not having been done is fatal to the presentation of the plaint or fatal to the suit. That is what I would like you to kindly.
Yes. Yeah.
Because the CPC doesn't say anything about it.
Eight and I. Now it requires stamped, adequately stamped. If it is not stamped, what will be the consequence? That has been spelled out under the Indian Stamp Act.
Section 35 and.
Yes. 35, 34, 35, 36.
Then impounding and penalty, stamp duty.
Right. Now, what is more worse, ଯଦି ସେଠି ନହେଲା ଏଠି ବି ସେ କରିପାରିବେ through the district magistrate or collector ସେ approve କଲେ ସେଇଟା ବି ନାହିଁ ଏଇଟା The wholesome reading of the so-called authorization letter makes it abundantly clear that the plaintiff Prabir Kumar Das does not authorize Sri Akshay Kumar Parija to sign, verify and swear affidavit on behalf of Prabir Kumar Das. Now, I will like to invite your lordship's kind attention to the evidence. I placed before, he must be acquainted with the facts.
Yes.
The person making presentation or authorized to present the plaint must be acquainted with the facts.
Yes.
Now, I invite your lordship's kind attention to the evidence of Akshay Kumar Parija.
PW?
PW 2. Paragraph 7. Examination in chief.
PW 1 ପରେ exhibit ଭର୍ତ୍ତି କରିଦେଲେ document ଭର୍ତ୍ତି କରିଦେଲେ ତାପରେ ପୁଣି ଏମିତି କଣ କରୁଛନ୍ତି ଜାଣିପାରୁନି
ମୁଁ ସେ ଟେକ୍ନିକାଲ ଟିକେ ସାର୍ ଯାଉନି
ନାଇଁ ମୁଁ ଏମାନେ
ମୁଁ ସେୟା ତ କହୁଛି
ଚାଓ ମାନେ PW 1 ରହିଲା ପ୍ରବୀର କୁମାର ଦାସ ଏକ୍ସାମିନେସନ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ସବୁ ସରିଗଲା ନାଇଁ ମଝିରେ କୋଉଠି ଗୋଟେ ପଶିଛି ଦେଖିବାକୁ ପଡିବ
PW 2 ଏଭିଡେନ୍ସ ଟାକୁ ଟିକେ ଦେଖ
ନାଇଁ ଏଇ ତ ଆରମ୍ଭ ହେଲା କିନ୍ତୁ ମେନ୍ ତାଙ୍କର ଯୋଉ affidavit evidence ସେଥିରେ ନାହିଁ 6 and 7 ଅଛି I filed my examination chief so and so this is the letter of authorization issued by the plaintiff marked exhibit 10 yes
then cross examination para 9
yes yes
he has deposed PW2 the authorization letter you got it
yes
the authorization letter was sent by the plaintiff to me through email and I have received the original authorization letter by exhibit 10 subsequently through courier. I have not filed the envelope in which exhibit 10 was dispatched to me. It is a fact that my signature is not available in exhibit 10. The plaintiff has not executed any general power of attorney in my favor to file this suit. The draft plaint was sent to the plaintiff by his advocate and after that I was authorized only to file this suit. Then take a very important gotiya sentence for it. I cannot say
yes
I cannot say whether the contents of the plaint are true or not. Then I do not have any personal knowledge about the development agreement dated 7/8/2020 exhibit A and supplementary agreement dated 8/8/2020 Exhibit B.
Yes.
My humble submission before your lordship is that he has absolutely no knowledge. Therefore, he cannot file the suit or maintain the suit on behalf of the plaintiff. Then, decision by right. Then, I invite your lordship's attention as the original authorization letter Exhibit 10 has been filed in course of evidence of PW2 and there is no proper application filed on behalf of plaintiff to substitute original authorization letter, that is Exhibit 10, with that of the photocopy of the authorization letter available along with the plaint is defective and without any authorization letter.
Right.
Then, the original authorization letter Exhibit 10 has been notarized at USA on 15/9/2021.
That point which you are referring to just now.
1 day subsequent to the issue.
Yes.
This is one aspect. Second aspect, it is not in stamp paper. Though I showed the notification that while notarizing it, a certain amount in American dollar is to be paid, no evidence is available before your lordship to confirm that such amount has been paid. So submission to your lordship is, what will be the consequence of a document which is required to be stamped and no stamp, appropriate stamp duty has been paid? It will not be admissible in evidence, according to section, as your lordship knows it very well.
Yes.
Now I invite your lordship's kind attention to paragraph 17 of PW1, plaintiff himself.
Yes.
But he has deposed on 14/10/2022. Your lordship got the
Yes.
date? Mine. He has deposed as follows. It is a fact that Akshay Kumar Parija has filed this suit as my authorized representative. Third sentence.
Yes.
It's a fact that I have authorized Akshay Kumar Parija to file this suit via letter of authorization, letter 12/9/2021. It's a fact that on 12/9/2021 I was present in USA. It's a fact that my letter of authorization has not been approved by consul or assistant consul of Indian Embassy. He admits that.
Yes.
It's a fact that my authorization dated 12/9/21 has not been confirmed by the district magistrate or collector for that. So the authorization available along with the plate dated 12/9/2021
Yes.
is no authorization. And on basis of that authorization letter dated 12/9/1991, there cannot be any valid presentation of the plant. So far as the other authorization exhibit 10 is concerned, that is dated 15/9/2021, that is defective on the count, though stamp duty of in US dollar has to be paid, does not show or clarify to have been paid, and that is cannot be admitted in evidence according to Indian Stamp Act in view of section 35 of the Indian Stamp Act. Second, I do not remember dita chhadikire tika dekhun seta paile. I do not remember.
Yes.
I do not remember whether the plaintiff is silent about the fact that the authorized representative filed the suit on my instruction. Because it may be contended by my adversary that suppose there is no authorization letter, this scrap of letter is not there, I verbally authorized. Whether that can be a valid authorization or not, your lordship may ask me that question. But my humble submission before lordship would be, the plaintiff himself says, I do not remember whether the plaintiff is silent about the fact that the authorized representative filed the suit on my instruction. He clarifies it. In fact, I have verified it, subject to correction by my young friends. I do not find this pleading in the plaint. He further said, probably the letter of authorization was sent through mail. This is about exhibit 10. If it was notarized on 15/9 at USA and sent through mail, it can be at best sent on that date or subsequent to that. By no imagination, it can be said that it had reached on 14/9 on the date of presentation of the plaint. Now,
Anything more on this point?
case law guda de de. Case law.
Case law ta pare dela ho.
ନାଇଁ ଏବେ ତା ସାଙ୍ଗରେ ଦେଲେ ଆପଣ ଯୋଉ ନୋଟ କରୁଛନ୍ତି ସେଇଟା that will be imprinted in my lord's mind.
Yes. Condition. State Bank of Travancore versus Kingston Computers. Yes.
ଦେଇ ଦେଇଛନ୍ତି.
Citation गुड़ा कौन थी?
2011 SCC 2011 SCC 524 ଗୋଟେ ଗୋଟେ ସାର୍ ପ୍ଲେସ୍ କରିବ
ये गुटा है तो?
ନାଇଁ
ଆଉ ଅଛି।
ଠିକ ଗୋଟେ ଆଇଡିଆ ଠିକ
ହାଇଲାଇଟ ହେଇଛ କୋର୍ଟ।
You can straight away come to paragraph 14.
ଆଜ୍ଞା।
paragraph 3 ଗୋଟେ
ଏଇଟିକୁ ଟିକେ ଦେଖିକିରି ଆମେ ଯିବା।
ହାଇଲାଇଟ କରିବି ଯୋଉଟା
Whether the suit has been signed, verified and filed by a duly authorized person.
ଆଜ୍ଞା। Signed, verified and filed by a duly authorized person.
Here the suit was dismissed
yes
Suit was
on the ground of lack of authorization.
authorized. Invalid presentation. After considering the pleading and evidence of the parties, the trial court decided all the issues except issue number 1 in favor of the company, but dismissed the suit on the ground that Sri Ashok Kumar Shukla was not authorized to file the same. The division bench of the High Court allowed the appeal of the company reversed the judgment of the trial court and decreed the suit by relying upon the letter of authority issued by Sri Raj K. Shukla in favor of Sri Ashok K. Shukla. Then last page.
Yes.
Paragraph 14. In our view, the judgment under challenge is liable to be set aside because the respondent had not produced any evidence to prove that Sri Ashok Kumar Shukla was appointed as a director of the company, and a resolution was passed by the board of directors of the company to file a suit against the appellant and authorized Sri Ashok Kumar Shukla to do so. The letter of authority issued by Sri Raj K. Shukla, who described himself as the chief executive officer of the company, was nothing but a scrap of paper because no resolution was passed by the board of directors delegating its power to Sri Raj Kumar K. Shukla to authorize another person to file a suit on behalf of the company. In the result, the appeal is allowed, the impugned judgment is set aside.
Since this point is over, we will continue on Monday. We'll continue on Monday. Next point कुछ भी हो judgment data they didn't. I understand. I have taken note of the point. I have taken note of everything. The problem is other some yes. What I will suggest is you may cite your judgments now, but take it back and find it after the completion of argument. କାହିଁକି ନା ସେ ବର୍ତ୍ତମାନ ଦେଲେ ସେ କୁଆଡେ ଚାଲିଯିବ ପୁଣି
ରେଫରେନ୍ସ
ନାଇଁ ଏବେ ଦଉଛୁ ସେତେବେଳେ ବି ଦଉ
ତାହେଲେ ଥାଉ ସେଟା ରେକର୍ଡ ଥାଉ
କେତେବେଳେ ଦବ ଅଛି ତ
ଅଡିସନ
ହଜିଯିବ କଣ ହବ ସେ
2014 ନାଇଁ କପି ଅଛି 2014 11 SCC 790
since we are I mean hearing will continue on Monday. Mr. Dabbag and Mr. Panda, if necessary, we will formally admit it, present the substantial questions of law, and nothing further is remains because you are all there. We'll hear it.
We are hearing it finally.
Finally, sir.
We will have the chance to reply.
But a formal substantial question of law frame कर दो. Yes. कर दो. ये तो सोमवार दिन कर दो. इधर नहीं जा. Now, I would have continued, but there are some one or two matters that are mentioned for urgency. It is an honor to hear you, sir.
It's my
Both sides. Chance to learn from both stalwarts.
Learning is unlearning process.
Sir. No doubt about it.
ଆଜ୍ଞା ଗୋଟେ ପ୍ରିଭି କାଉନସିଲ ରିମାଣ୍ଡ ହେଇକି ସେକେଣ୍ଡ ପିଲା ଆସିଥିଲା ଆମେ ସମସ୍ତେ ବିଜେତା ସମସ୍ତେ ଦେଖୁଛୁ କିଛି ପାଉନଥାଉ ଆମର ଯେ ମାଷ୍ଟର ଥିଲା ଆପଣ ଜାଣିଥିବେ ମହୁରୀ ସିଏ ଶୁଣୁଥାଏ ଶୁଣିକି ଗୋଟେ ପୁରୁଣା ଫାଇଲ ପୁରା ଗନ୍ଧିଆ ହେଇଯାଇଛି ଆଣିକି ଦେଲା କହିଲା ବୁଢା ବାବୁ ଏଇଟା କରୁଥିଲେ ଦେଖିଲେ ଆଜ୍ଞା ସେଇଥିରେ ଦେଖିଲେ ଏବଂ ଜିତିଲେ ସେ କେସରେ
Well, and the previous modules of those days and today also in Balesore. But it is he there? Is he not there? Okay. No, I think she mentioned what item 31. Yes. Obviously, it will be after lunch because first half the supplementary list is there.
item 41.
No, 41. Where Mr. Solangi he has made a mention thrice or 4 times. I wanted to take it up today. Not there. How tell chada only go to tap tell dekhiya. Serially chalo.
Item 27.
27. Yes, item 27. Anybody?
Lordships, I am appearing virtually, my lords. I may be allowed here.
Yes. Virtual for civil matters.
Lordship.
Why are you not coming to the court, Mr. Das?
Lordships, today some difficulty, my lords.
Yes, what is this?
Again, it's a short issue. My lord, I on the other occasion also, with all fairness, my lord, considered that the law point is against me, your lordships.
What is the point? I don't know. What
I've just briefly, I'll state, my lords. The sole point being the substantial question of law is this, my lords, that whether payment of an encroachment fine by the plaintiff, under coercion or threat of dispossession, will amount to an admission of title of the state and thereby negativing the hostile animus. And consequential question that will follow is whether the plaintiff in that case can be.
No, you're not audible. Your voice is not audible. Your voice is not audible, Mr. Das.
Am I audible now, my lords?
Now you are audible. At times your voice is going away. That is why I say that you should come to the court. We'll take it up next week. All right. ଆପଣ ଅଧା କହୁଛନ୍ତି ଅଧା ଶୁଭୁଛି ଅଧା ଶୁଭୁନି. All right. We'll take it up next week. Don't worry. But then, as you have yourself said, the law is probably.
Law is against me, my lords.
Yes,
And
yes.
my lord, even
Payment of penalty by an encroacher.
Yes.
Anyway, let's this matter next week. That's prayed for.
Item 28. Item 28, this second appeal has been admitted.
Already admitted?
Yes.
Admission has seen, hearing it. Hearing.
No, notices have not been sufficient for which.
So that is why it has come. Notice has.
Dated, your lordship admitted on 16/5.
Oh, undelivered from respondent 3 with the postal report address is moved. From respondent 4 with the postal report address is left without instruction. AD not back from respondent number 2. Postal tracking report.
I will have to ascertain the correct address now if I get it.
No, but respondent number 2, it will be sufficient. Respondent number 1 has entered appearance. Respondent number 2 delivered.
Tracking report.
Notice on respondent number 2 appears to have been delivered as evident from the postal tracking report. As regards notice on respondent number 3 and 4, learned counsel for the appellant is directed to take fresh notice, furnishing the correct address. Requisites be filed within 1 week. 1 week. Notice be made returnable within 4 weeks. List this matter. September. In the week commencing 23rd September. Yes.
Item 29.
29, yes.
My lord, may it please your worship. My lord, the petitioner is an illiterate woman, your lordship.
Yes.
The petitioner happens to be the defendant number 2 in the trial court. Now,
Urmila Devi.
Urmila Devi.
Yes.
She puts her LTI, your lordship. So, the petitioner challenges the judgment passed by learned first appellate court.
Yeah, what was the suit for?
My lord, suit for
Suit for
specific performance of contract.
Yes.
That is filed by respondent number 1.
What was the contract?
The contract was that on 5/9/2014, respondent number 1 says that he has entered into a contract with me and my husband that for 42 lakhs, 1.5 acres of land situated in the heart of the Sambalpur town will be sold to him. And it is to be done within 3 years. If it is, since he alleges that it has not been done within 3 years, so he has to file the case.
Yes.
Now, your lordship may kindly see. Your lordship may kindly see page 10.
Page 10 of?
Page 10 of my brief. That the first, your lordship, point of law when I have stated.
No, what happened? Tell me the facts.
My lord, thereafter what has happened, your lordship? So, see, he contested the matter as a plaintiff. The learned court below has been pleased to direct the appellant to execute the sale deed. But there was no finding regarding possession. There was no finding regarding insufficiency of consideration as an issue. Now the matter was carried to first appellate court by the.
So what was your standard? Are you disowning that contract?
Yes, your lordship. My submission is that, your lordship, inadequacy of the consideration is very telltale, my lord. The learned lower court has simply passed a remark that inadequacy of the consideration cannot be just only one line, that inadequacy of the consideration cannot render the contract void. I do admit, my lord, inadequacy of the consideration may not render the contract void.
Because you have entered into a contract.
But that, yes, Lord, that will be taken into account by the learned court below to find out whether the consent is free or not.
No, but I just want to understand, Mr. Mishra, whether you say that there was a contract or
yes, my lord.
You admit the contract.
My lord.
No, but you started by saying something about illiterate lady. So
my lord, illiterate lady means when say again Jani Parnandi. The inadequate, your lordship may consider it a Madhupur, Sambalpur in the heart of the town.
Yes.
The area is 1.5 acres. In every case of your lordship's specific performance, generally an alternative prayer of return of money is made. Deliberately he has not filed. the learned first additional discharge has been pleased to hold certain criteria regarding specific purpose, in which case it is to be done, it is not to be done, with reference to honorable judgments by honorable courts. There are also the learned.
No, what was the dispute? Let me first understand. What was the cause of action? Why did he come to the court?
The cause of action is that both the courts will have directed me.
No. For filing the suit.
The suit was that he is saying that I have not executed the agreement.
Achha.
That is the dispute. He is saying that after receiving 12 lakhs amount, I have not, out of 42 lakhs was the consideration.
But there is no such issue. Issue number 3. What I find is that whether the plaintiff breached terms of the contract by taking away the alleged check of rupees 2 lakh from the defendants and not paying the said amount in cash afterwards.
That is my point, that he is saying I have given 12 lakhs. It's not a fact. He has given 10 lakhs. Admitted, your lordship. 2 lakhs he has given in check that he took away, that he returned on the plea that I'll pay it in cash. That he has never paid. Your lordship may kindly consider.
So what was the finding of the trial court?
Trial court gave a finding that he is not in possession. Regarding possession of part, the trial court said that he is pleading false thing, the plaintiff. That is the clear finding of the trial court. But the trial court has been pleased to direct that the agreement is to be, the sale agreement is to be executed. The sale deed has to be done.
So what about the first appellate court?
First appellate court simply accepted it. Your lordship may kindly say, I am only reading page 25. That is a part of the trial court judgment.
Page 25.
My lord.
Just a moment. Yes.
Regarding, your lordship, the first line I am reading, has the pleading and the evidence adduced by the plaintiff is not cogent and consistent enough to establish that delivery of possession of the suit land was given to the plaintiff, because he is specifically saying I have delivered the land to him, which is not a fact. It is still in my possession. There is a finding by the learned trial court that this possession part he is falsely paid. And execution of the plaintiff, after execution of the alleged agreement to sell by Exhibit 1, and the plaintiff developed the suit land by spending a sum of rupees 8 lakhs and 50,000 rupees. However, the fact of delivery of possession of the suit land to plaintiff is not an issue in the present suit. The main issue is to be seen whether the plaintiff is ready and willing to perform his part of the contract and whether he is entitled to the relief of specific purpose of the contract or not.
Basic ingredient.
My lord. So my respectful submission, your lordship, on 2 points, your lordship may consider. The first thing is that he is saying the admitted fact is that the agreement executed on 5/9/2014.
Yes.
And there is a period of 3 years. So the case filed on 18/8/2017 is to be outrightly rejected, because 3 years has not been completed by that time.
We'll admit it on A and B.
A and B, my lord. And inadequacy, A and D, my lord. If your lordship will permit, this inadequacy of consideration, may I read only 1 point, my lord? My lord.
So this will be factual. D will be factual. B will rather will.
Lower court pura side track kar dele.
No, that is true. But that what the way you have framed it is quite factual. How can the court decide whether it is being in the heart of the town of Sambalpur, it will fetch a
factual.
factual is
pura factual. Kintu again, inadequacy of consideration, whether it's a ground to be framed as an issue or not.
Yes, that will be concerned. All right, heard Sri Ashutosh Mishra, learned counsel with the appellant, peruse the imputed judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 10, A taku korandu, B taku korandu, C taku whether the courts below were correct in holding that inadequacy of consideration can be a ground to invalidate the contract between the parties. Issue notice to the respondent and the respondents.
Not required.
Issue notice to respondent number 1 for the time being. By registered post with AD, returnable within 4 weeks, requisites be filed within 3 working days. Place this matter. A call for the LCR.
30th September.
Huh?
30th September.
All right. 30th September. Yes.
I have filed an IA.
Status quo with regard to the suit property as on date be maintained till the next date. Yes. Yes, Mr. Solagi, 5 ଥର ଡକା ଚାଲାଣି ଆପଣ 4 ଥର ମେନସନ କଲେ କଣ କୋର୍ଟ ଟାକ୍ସ ଚାଲାଣି 5 ଥର
ସରି ମାଇଲର ଡକ୍ଟର ଆସିଲା ଗୋଟେ
ତାହେଲେ ଆପଣ ଯୋଉ 4 ଥର ମେନସନ କରିକି କୋର୍ଟ ଉପରେ ଦୋଷ ଦଉଥିଲେ ସେଟା କଲା
ସରି ମାଇଲର
ସେଟା କଲା
ମୁଁ ଥିଲି ଜଷ୍ଟ ଖାଲି ଯାଇଥିଲି 10 ମିନିଟ୍
ସେଇ ତ ସେତିକି ଭିତରେ ପଡିଯିବ ଆପଣ ଜାଣିପାରିବେ କଚେରୀ ବରଖାସ୍ତ ହେଇସାର ତ କୁହନ୍ତୁ କଣ ଅଛି କେତେ ଆଇଟମ କେତେ
ମାଇଲର
ଆଇଟମ କେତେ
ଆଇଟମ 40 ମାଇଲର
କଣ ହେଇଛି କୁହନ୍ତୁ
ମାଇଲର in this case
admission
the respondent filed a petition before the land action reference case the title suit how first appeal already disposed of and order in favor of the respondents.
No, this matter has been admitted already.
Admitted, my lord.
Who is appearing for the other side? Somebody is appearing for the other side. I think respondent number 2, 4, and 5. Somebody is appearing. Mr. B. Saab, Mr. B. Mahanti. Have you served copy on him?
ସେତେବେଳେ notice ଯାଇଥିଲା ତାଙ୍କ
No, IRA notice ଯାଇଥିଲା.
He present item expeditious କରିଛି but that time also
notice ଟା ଦେବେନି other side କୁ
order by special ଆସୁନାହାନ୍ତି order may be ଯାଉ by special pion or by speed sport କିନ୍ତୁ ସେ ଟଙ୍କା ନେଇଯାଉଛନ୍ତି 10 day after tomorrow, my lord. If the entire case land is the land acquisitions ଟଙ୍କାଟା ମୋ ଟଙ୍କାଟା ସେ ନେଇଯାଉଛନ୍ତି. This is a case, my lord. Case in purchase already
ठीक देखिए let us see whether both the courts below have erred in law by not relying upon the willnama which is admitted by the respondent without any objection. No, somebody has appeared, na. Press requisites with correct address be filed for issuance kola.
Correct address
interrupting of the appellant without taking consent. Somebody has appeared, Mr. B. Sahu, B. Mahanti, respondent.
My lord, can see the earlier order, my lord. Earlier order भी नामକୁ ଯାଇଥିଲା notice. Issue notice to above, accept one set process.
Yeah, that is true. But somebody also appeared.
My respectful submission, if the case is admitted, suit ଆଉ first appeal ସହିତ କିଛି no relations. ସେମାନେ petition ଦଉଛନ୍ତି ସେଠି କଣ? First appeal ଆଉ suit already disposed of. That is the order. So second appeal admitted. The ଟଙ୍କା ନେଇଗଲେ ମୋ case is infructuous.
No. Somebody has appeared. That is what I am saying.
My lord.
For respondent, somebody has appeared. So you serve a copy on.
କିଛି ଖାଲି short ନା ରହିଛି ମୁଁ ବହୁତ ଖୋଜିଛି କିନ୍ତୁ ମୁଁ notice ଟା ଦେଇଦେବା ପାର୍ଟିକି ଆଉଥରେ
କେମିତି ପାର୍ଟି କାହିଁକି ଦେବେ
by speed post, my lord.
ये सତ କଥା B. Sahu election କଣ election ଜଣା ପଡୁନି.
ନାମ ଦେଖୁଥିଲି verify କରୁଥିଲି
B. Sahu and B. Mahanti.
ମିଳୁନି କି ସେବେ ଆସୁନାହାନ୍ତି. My lord, kindly see ମାନେ ମୁଁ ପଠେଇଦେବି speed post ରେ ଆଉଥରେ second time. Status को भी maintain at least.
Yes, status quo will be maintained. I am willing to pass that order, but how? Without hearing the other side, how can we do that?
नहीं ତାଙ୍କୁ notice ଦିଆଯିବ ଆଉଥରେ ତାଙ୍କର କାଉନ୍ସିଲରଙ୍କ ଆଡ୍ରେସ ନାହିଁ କି ଫୋନ ନମ୍ବର ନାହିଁ ସେଥିରେ.
Sri Ashok Kumar Sarangi, learned counsel for the appellant. That IRA କରିବୁ ହେଲା. Submits that despite pendency of the second appeal before this court, the
LA case
in question is about to be finalized and the compensation amount is likely to be disbursed in the near future. So it is submitted that in such event, the appeal itself would become infructuous and the appellant would thereby be prejudiced. None appears for the respondents despite repeated calls. Despite repeated calls throughout the week, the matter being in the weekly list. Considering the submissions as above, this court directs that LA case number 15 of 2020, LA reference case number 4 of 2018,
arising out of LA case number,
arising out of LA case number 15 of 2020, pending before
Civil Judge Senior Division Sundargarh.
Civil Judge Senior Division Sundargarh shall remain stayed till the next date. Yes. List this matter on what date karo? Huh?
We commencing 27th August.
In the week commencing 27th August. Yes. Remaining matters will go to the next week.
Right.
Because tomorrow there will be no court, so remaining matter. Yes. You are appearing person. Yes.
Appearing person. More last list.
Who matter? Quote.
50 ଅଛି supplementary last 50 ଅଛି.
କଣ ହେଇଛି କୁହନ୍ତୁ?
Time take it Monday or Tuesday maximum.
Yes. ହଁ କୁହନ୍ତୁ କଣ କହୁନାହାନ୍ତି? ଏଟା ହିୟରିଂ ଅଛି ନା?
Hearing
2024 matter hearing.
Milord actually କଣ ମାନେ 5.4 crores.
What is your good name, sir?
Shiva Prasad Kara.
You are appearing for the respondent. And Mr. Mahanti is appearing for the. You want to inform Mr. Dwarika Prasad Mahanti so that I can take it up next week on mention? Please inform me.
Okay.
So, this is a 2024 matter. Normally,
Lord, after is a concurrent finding. अब ମୁଁ actually ଘର ସେ ନେଲା ଜଣେ ହୋଟେଲ ଟା ମାନେ ପାଇଲିନି ମାନେ
it's all right, whatever.
ପାଇନି
No, ଠିକ ଅଛି ଫ୍ୟାକ୍ଟ କହିଲେ ଆପଣ କଣ ଆପଣ ନେକ୍ସଟ ୱିକରେ ଆସିବ ଆପଣ କହିଦିଅନ୍ତୁ ମିଷ୍ଟର ମହାନ୍ତିଙ୍କୁ କୁହନ୍ତୁ the court has asked you to say that. Yes, sir.
Item number 35. On the first occasion, it was heard on behalf of the appellant and it was, hearing was completed.
Hearing was
Therefore, I request this may be listed as part heard matter. Item 35.
Nobody had appeared for the other side.
Other side,
Somebody had appeared.
appear करते
अच्छा.
कौलास्कर appear करते आज गोटे भी तार note of submission दे देइछन
नहीं से लिखा है Mr. Coral and counsel to the respondent submits that the brief has been taken away from him, but he undertakes to inform the court as to who had appeared in this case.
Sir,
So
ସାରଙ୍କର ଗୋଟେ ଟେଲିଫୋନ ଆସିଲା ସାର୍ ଗଲେ ଯୋଉ ଗୋଟେ ହେଲ୍ଥ ଚେକଅପ୍ କରିବାକୁ ରିଟିନ୍ ନୋଟ୍ ଅଫ୍ ଏଇଟା ଦେଇ ଦେଇଛନ୍ତି
no, ମାନେ you won't would you not like to argue the matter?
sir,
I'll keep it to next week finally. One chance I'll.
से तार note of submission सेटा
No, ସେଟା note of ରଖିଥାନ୍ତୁ that it should not be interfered with. Anyway, should I keep it to next week only for one chance? देखिए जगह हो 2010 matter.
next week
No, weekly list as well, any day. Just recapitulate, sir. We'll do it. We'll complete it. I would have taken it up today or tomorrow, but tomorrow since there will be no court, so I'll keep it to next week then.
next week as part heard us.
All right.
In fact, hearing.
All right. Heard in part. This is matter next week. Part heard कितना है? ना पास टाइम ये रख दो. इधर सॉरी ये चीज़ खाली आउटर recapitulate कर दो ना.
I didn't make a mention, Your Lordship. Item 19 is a delay of 2 days in filing the
19.
Again, there is a delay of 2 days in
Item 19 पास हो रही थी. आरो वीकली देखिए नोटिस तो जीवो. मैंने what are you holding?
The brief, Your Lordship.
नहीं नुआ कौन फाइल को item 19 next week. All matters will be next.